Counsel.
Acting Chief Justice and Deputy Chief Justice, Advocate M. Mpaga SC. I'm acting for the second respondent with Mr. Manala. Oh, first and second respondent. Or third respondent. Yes, thanks. Second and third.
Can you please say that again? Just start it for whom?
For second and third respondents.
Oh, thank you. Thank
Thank
you.
you. Thank you.
Thank you, Counsel.
May it please the court, I appear for the fourth and fifth respondents. That's the Minister of Finance and National Treasury, together with Mr. Tsetlo.
Thank you. Thank you, Counsel.
May it please the court, Deputy Chief Justice and other justices, I appear for the sixth respondent, represented by the Liquidator.
Thank you. Thanks, Counsel.
Acting Deputy Chief Justice and members of the court, I appear for the eighth respondent, Rain Chartered Accountants.
Thank you, Counsel.
Good morning, Justices. The name is Jonathan Blow. I appear with Ms. Acker for the 11th respondent, Lasaka Technologies.
Thank you, Counsel. That's all the appearances. Am I not mistaken? Should be. Mr. Blow? All right.
Yes.
Thank you. I just wanted confirmation that all counsel have now placed themselves on record.
Yes, I don't think there are. I think all of the other parties are not represented at this hearing.
Thank you.
Thank you.
Thank you. Yes, Mr. Kutsudis.
Acting Deputy Chief Justice, before Mr. Kutsudis start, may I just ask, there are a number of people in the waiting room. I'm not sure if perhaps Justice Theron recognized any of them, but if the parties could just confirm who these are. Feziwe should be admitted or not. Lufefe, Iraf Byrne, Disemelio Tladi, Anesu, Opaetete, I think that's a law clerk, am I right? And Mike M.
That's my law clerk. Please admit her.
Admitting and Mike M. Can people please confirm this?
Justice Madlanga, please, if the law clerks can identify themselves as law clerks by their names, please, then we will know.
Okay. Yes. All right. Thank you.
Okay.
And do any of the counsel recognize the names that my colleague Justice Majid read out?
Let me go through them again. Feziwe, Lufefe, I'm told Lufefe is a law clerk. I'm admitting her.
Feziwe and Lufefe are attorneys.
We should admit them?
You can admit them.
Then Iraf Byrne, law clerk. Disemelio Tladi.
Sorry, yeah.
Disemelio Tladi. Okay. Anesu. Mike M. Okay, then ADCJ, thank you for the opportunity. I'm not admitting the others then. Thank you.
Thank you very much. Thank you, Justice Majid. Yes, Mr. Kutsudis.
Acting Chief Justice, thank you so much. We're actually Deputy Chief Justice. Acting Deputy Chief Justice, my address to the court, I'm going to break it up into three major chapters, just to give you an overview of where I'm going. I'd like to begin, because I think it's very important in this matter, given the history, to position that history and the major judgments of this court that have shaped where we are and the obligations that we say exist at the moment for accountability. and also compliance of court orders. After giving that history in my second chapter, what I want to address the court on is really what the problem is. Why are we here today? What's happened? Why we say that two things have seriously broken down. Firstly, the very public accountability that this court required from All Paid 2 all the way through its judgments, 7 in all, has broken down. The public doesn't know the profits and benefits CPS made. And we say that's a problem for two reasons. It's a problem for compliance with the constitutional obligations of accountability on CPS as an organ of state. And it's a problem for compliance with this court's orders, which are rule of law obligations that must be complied with. And this court has said it continues to have jurisdiction and the power to ensure its orders are complied with. In fact, I think acting DCJ, that was in your judgment in the reign that you made that point. And we will take the court to what's broken down. Where are we now? What's the problem? What's the issue? And then, of course, the third chapter, which is, of course, how do we solve that problem? And what should happen now? And I accept that this court has agonized over that. And we witnessed the various directions and we have engaged with them and thought through them. And I know for my client, Freedom Under Law, or Phil, we filed 4 different sets of heads in this matter, just this particular latest round. And we accept that this is a difficult matter. And my submission to you ultimately will be that this court and the justices of this court must not weary of doing justice at this last stage. And that will be my overarching submission, that your just and equitable powers are extensive, and you have repeatedly reminded us that they are precisely for such intractable issues, that the wisdom that this court has shown from the earliest All Pay days, we feel can guide us through to a final resolution, and that we shouldn't, at this last stage, give up. That will be my ultimate submission in chapter 3, but I will address the practical questions that you have, of course, in that. So without much further ado, let me start, because I know I only have 30 minutes, and then I accept that the real fun will begin, and you can ask me all the questions you have been waiting to ask me. Can I start a bit unconventionally? The story for this case really begins in All Paid 2, but I want to start at the very beginning. The first words that this court said in All Pay 1, which I think is important to frame what this is really about. This court said, paragraph 1, Justice Froneman's judgment, for many people in this country, the payment of social grants by the state provides the only hope of ever living in material conditions that the Constitution values of dignity, freedom, and equality. About 15 million people depend on the payment of these social grants. They are vulnerable people living at the margins of affluence in our society. And that is the framework that this court, that was what this court was facing in All Pay 2. It had a situation where a private company had taken on the responsibilities under Section 27 of the Constitution to ensure the constitutional rights of some 15 million South Africans. It was a unique situation and a unique tender. And this court therefore agonized what to do, because it had to weigh 2 competing issues. It had to, on the one hand, hold the fact that unlawfulness should be brought to an end, that the corrective principle that this court established in paragraph 30 of All Pay 2 required unlawfulness to be ended. But on the other hand, there was a significant tension, because as All Pay 1 reminded us, there were 15 million South Africans, the most vulnerable in this country, who had become dependent on cash Paymaster Services to provide their rights. And in the midst of that tension, this court came up with an elegant solution. Not perfect and not answering all the issues, but an elegant solution. And Justice Froneman said 2 things, and this court said 2 things. Firstly, it said, CPS is in fact an organ of state for the purposes of this contract. It has assumed the status of an organ of state. And what this court said in All Pay 2, from paragraph 52 is that it is assumed for the purpose of the financial nature of its work, public accountability obligations tantamount to being an organ of state. He said that, and then he said this, because what was happening, and what you'll see in paragraph 61 of All Pay 2, is CPS was saying to this court, well, if this contract is invalid, we can walk away. We're not obligated any longer. We can walk away. And this court said, no, I'm sorry. You can't walk away. 15 million people have become dependent upon you. So what this court said in paragraph 66 and 67 was to say, we accept that because you can't walk away, you're not expected to make a loss. But on the other hand, you can't benefit, because you can't benefit from threatening the rights of individuals. You can't benefit from unlawfulness, this court said. So it said the solution is that you must account for what benefit you make, and you must account to this court. And that is what was said in paragraph 67 of All Pay 2. And importantly, what was then ordered was not just an accounting by CPS, but that SASA then did an independent verification of that accounting. This court then, to move forward quickly, this court then confirmed that principle in All Pay 3 in paragraphs 15 and 16. It said, it repeated the fact that CPS may not benefit from the unlawful contract, and it said it must account, and it referenced this order as requiring not just its own accounting, but a verification by SASA. And it stated that this court retained jurisdiction to ensure that accounting happened. And that's in paragraph 15 and 16 of All Pay 3. Then Black Sash 1. Once again, what happened then is that it became clear that SASA was not in a position to take over the payments of social grants. So this court extended the declaration of invalidity even beyond the initial 5-year contract for a further 12 months. And it required CPS to continue under the unlawful contract. But it made very clear that once again, CPS continued to have public accountability obligations. And it said once again, and this is from paragraph 50, what Justice Froneman says in paragraph 50 is, the equilibrium that we established in All Pay 2 continues, the no profit, no loss equilibrium, because that is bound up in the just and equitable relief we gave. That was the way we held this intention. You can't profit, but you can't make a loss. And therefore, the court said, once again, we're not allowing you to claim more money now. You must once again account to us. Have you made a profit or not? And once again required reporting of that. This time, the court specifically went further to protect that accountability and required not only a verification by SASA, but that Treasury approve the verification. It also made clear that SASA's financial information had to be available to the auditors appointed by SASA. In the SASA matter, which happened a year later, once again, the court did a further 6-month extension. And again, the same principle applies, the same accounting is required, and same verification by SASA's auditors and approval by Treasury. So there we have 4 initial judgments, which all confirm that not only must CPS not benefit, but there must be a proper accounting to this court of that benefit, if there is one, which includes an independent verification. Then we fast forward to the freedom under law matter, which was decided, an order granted on the 1st of April 2021, but the litigation was launched in April 2020. And once again, what had happened there is that, as this court well knows, but this is quite important, so I want to just go quite slowly over this. So RAIN had been appointed as SASA's independent auditors, but there was a significant issue in its ability to verify, because it said it was missing significant amounts of information from CPS, from KPMG and MZAR, who were CPS's auditors. And it said to this court in a draft report, we don't know the final number, but we can tell you that it looks like CPS has understated through its auditors, its profit to you by 800 million rand. So its stated profits to you were approximately 252 million. But Rain said, on our initial assessment, we are concerned that this profit is understated by 800 million. And on the basis of that, Freedom Under Law came to court and said, well, they need to be given what they require to do this work. And this court confirmed that that was required. More importantly, this court also said to us, because, and may become important for the remedy issue if we get there. CPS, Freedom Under Law had done two things. We said primary relief we would like is that everything that is required by Rain is given to them. And then we said, we would like a situation where we need an endpoint. So we said to this court, if for any reason Treasury can't approve Rain's verification, then Treasury must do the determination. But we accepted that maybe Treasury may not be able to have everything it needs. So we said that it can come to this court and ask for what it needs. So we asked for that relief, and that was unopposed. All the parties accepted that, including Treasury. Everyone did not oppose the obligation being placed upon Treasury to do a determination if it felt that Rain had come short. So everyone accepted that obligation. No one opposed it, and this court granted that order and placed that obligation on Treasury. Beyond that, and this may become relevant, Freedom Under Law also said, just to be clear, if it so turns out that CPS has made a profit, we want this court to declare that that profit is repayable, because we said the whole purpose of this accounting has always been that the profit should be repaid in principle, or at least that this court must determine whether it should be repaid. That's why it wanted the accounting done for two reasons. One is for public accountability, and secondly, we said because that is the ultimate way to ensure justice and equity, to ensure that it didn't profit. If it is turned out that it did profit. Now, CPS opposed that relief. And this court then said, and this becomes very clear if you look at paragraphs 10 and 13 of the Freedom Under Law decision of April 2021. This court then said, well, because CPS, no other parties opposed this, SASA didn't oppose this, no one else opposed it, but because CPS opposes this declaration, we will defer that declaration, you said, and we will defer it until such time as this court has the information it needs. And that's what it said. Now, if I can just, because this is of some importance, I might just read what was said there in paragraph 13. And what was said is this: having considered all the affidavits filed in this matter and the parties' written submissions, we have concluded that the parts of the relief which is not opposed should be granted, and the determination of the opposed part of the relief, now that is the part where we sought a declaration, must be deferred, it said. There can be no doubt that the updated verification report by Rain would be material, and this is also important, would be material to an inquiry on the profit earned by CPS from the illegal contract. So this court recognized the materiality and importance of knowing the true profit and from the investigations that Rain was doing. And then it said, consequently, it would be proper to consider the issue of profits, meaning whether they should be repaid, once all the necessary information is placed before the court. So this court said, well, once we have all the information in relation to the profit determination, at that stage we will consider. And that, to our understanding, has always governed the position, which is this court will only consider the question of that it's deferred once it has a proper accounting before it. So that was Freedom Under Law. Then came the Rain decision. And I promised to stop the history in just two more cases. And I thank you for the patience of this court. I know because you've lived it, as have we, that perhaps some of this is unnecessary, but it's important just to recall all the threads. So coming to the Rain decision. The Rain decision is made on the 10th of September 2021. Why is that important? What Rain does is Rain has a difficulty. Because it's being required to do more work, this court recognizes it needed a further contract. There was some dispute between it and SASA about whether or not such a further contract should be ordered. But this court importantly recognized the following. it recognized that one of the reasons Rain really had to be allowed to continue the work, and this appears at paragraph 11, is because this court said that it states without dispute, let me put it that way, that Rain had identified a critical issue, very critical. It said Rain had identified through its investigations that there was profit shifting within the LASACA or Net1 group, that there had been an attempt, Rain finds, to shift profits away from the company that might be liable. And that was of major concern to Rain. It said this is a significant issue. It requires significant re-investigation. And of course, we say the same, because of course, if that were true, I don't want to put too fine a point on this, but if that were true, it would suggest that this court was misled. Even if that was innocently, it would be a significant issue. In fact, this court in this very matter took umbrance when the Minister of Social Development sought to mislead this court in relation to what she had done. And that became the subject of the last Section 38. So it would not be a matter of small moment if the very public accountability that this court had ordered had been thwarted by attempts to shift and hide profit in a group. That would be of significant importance. And of course, that's why this court, without demur, says that this was a critical issue, so critical that this court says in the Rain judgment that it's important to allow Rain, even if it requires an emergency tender. And in fact, Acting Chief Justice and Justices, if I can read the relevant portion from that judgment on that point. In paragraph 32, you say, Acting Deputy Chief Justice, although it is not for this court to decide whether there must be a deviation in this matter, i.e. a deviation to a point to give Rain a further contract, I would be failing, this is what you say, I would be failing in this court's duty if I were not to make comments that are of relevance to the subject. This court's duty stems from the fact that it is in the interest, it is in its interest, the court's interest, but I would say also the public's interest, that the issue of CPS's profits be finally determined with expedition. So this court recognized the importance that, firstly, that we hadn't got a proper determination. Why had we not got a proper determination? Well, of course, because the expert accountants are saying, we've investigated this and we have a serious concern here that there's been improper profit shifting. So that's Rain. And then the last in my long list of judgments is your long list of judgments, is the Cash Paymaster Services judgment, which is on the 11th of February 2022. And that judgment was because the provisional liquidators had sought a variation of this court's orders, because they said, well, we're provisional liquidators, we want a variation. This court dismissed that. But importantly, this court, in its conclusion, makes a statement that I think is very important. And if you'll bear with me just to read that to you, in paragraph 24 of that judgment, this court says the following: but the compliance required from CPS in terms of the April 2021 order, now that's the order in Freedom Under Law, which was repeated in Rain, the order that obligates Treasury and for a final determination. The compliance with that order, they said, has nothing to do with the winding up of the company. It goes on to say this: the April 2021 order is the last in a series of just and equitable orders made against CPS in the exercise of this court's jurisdiction under Section 172(1)(b), following upon the declaration of constitutional invalidity on the 17th of April 2014. That's all paid to. And then you conclude, I'm going to skip a few lines. Compliance with this court's April 2021 order, however, is not optional. And there is thus no reason to delay compliance. And we would say, well, that frames much of what we would say, to use this court's own words. It's compliance with the order is not optional. And then the question is, well, if compliance with the court's orders is not optional, and this court requires, as the court said in the Freedom Under Law matter and Rain matter, it requires a final determination of the profits and requires the information to be put. If that's true, if that holds, and we say, well, this court has said it holds, we would say, at least in 3 judgments, But I would go beyond that. I would say in 7 judgments, it's required those. There are 7 judgments that all obligate a full determination of CPS, a full and independent determination. If that's true, then the question becomes this: do we have that? Have we achieved public accountability? Has this court its orders been given effect to? And we say no. Why do we say no? Well, we say no for very important reasons. We have 2 expert reports that are before this court, but one at least in the most recent expert report, which Treasury has attached to its affidavit, where the expert accountants, independent expert accountants, come to this court and say, look, we've done an investigation and we have ongoing significant concerns. We haven't been able to get all the information we need, but the information we have got has been deeply concerning to us. There are significant profit issues of profit shifting and expenses that shouldn't have been accounted for. And can I just give 2 examples of that? Just to show you why I think that this is of some moment to us. In paragraph 21 of Rain's further explanatory affidavit at page 583 of the record, it talks about the fact that this court will have as a concern profit shifting. And then it footnotes an example of that, which is the royalties that CPS paid to SASA. And I'm not going to read all of this to you, but can I just give you this reference, Justices? At page 86 to 89 of volume 1, that is the record, the report done by Rain. At pages 86 to 89, what Rain does is it talks about this question of the intergroup royalty payments. And it tracks through each month. But it's what I think is very important, and I just want to draw this court's attention to, is the way that those payments suddenly jump in and increase. So what happens at the beginning of the contract in April 2012? The royalty payments are 6 million rand a month to SASA. And that continues for 2 years, up until April 2014. So 2012 to 2014. So if you look, so what happens is the royalty starts in April 2012 at approximately 6 million, and it continues at approximately 6 million for 2 years until April 2014. So for 2 years, consistent, right as consistent, 6 million, 6 million. And then suddenly, in May 2014, there's suddenly a royalty payment of 198 million rand. So 6 million, a sudden jump to 189 million. Then it continues after that from June 2014 at 24 million. And now there's a payment of 24 million. But before taking you through all this interest, can I say something? Can I make a point here? The courts, what Rain says is that this is not properly explained. The documentation doesn't properly explain how royalty payments could have had such a big jump and why this full lump sum payment was made, but more importantly, why the royalty payments jumped from approximately 6 million rand a month to 24 million rand a month. That's a 4-fold increase, which means that from rather than 72 million rand a year royalties, you've suddenly got almost 300 million rand a year royalties. And what's fascinating to me, because I've lived this case since the beginning of Allpay, is this. Do you know what happens on the 17th of April, 2014, 2 weeks before the sudden jump? This court's judgment in Allpay 2, where it says that the benefits must be accounted for and you may not benefit. 2 weeks later, surprisingly, there is this massive amount of royalties being paid and a significant 4-fold increase in the monthly royalty payments, which then continues all the way through. But then what we know is that in June 2017, there's a further massive payment of 117 million. And thereafter, the money goes to 33 million rand a month royalties. And of course, as you know, what happens in March 2017? Well, this court says that the invalid contract is extended. And once again, CPS may not profit and must account for its profits. And we say this must be investigated, because what we have is a massive increase in royalty payments intergroup. And of course, this is not an arm's length situation. What the papers tell us is that CPS's directors are all appointed by LASACA, that LASACA is its majority shareholder and controller, and that they have the same company secretary. That company secretary, I'll give you a reference. The liquidator says at paragraph 16.3 of the further affidavit at page 458, volume 6, they say that Ms. van Straten, who is the company secretary of both LASACA and CPS, says that the accounts between LASACA and Net1 were interwoven and that there was no separate accounting between LASACA and Net1 in respect of the SASA contract. So when you put those facts together, we say there's a significant concern around that. Lastly, I want to point out to this court that one of the questions that Rain asks and the Treasury asks is in paragraph 21, page 29. So volume 1, page 29 and paragraph 21. What the Treasury says is another question we have for you is why, firstly, the royalties don't make sense to us, this sudden increase. But more importantly, these royalty payments are not in line with the tender submission you made. Now, in response, neither CPS nor LASACA can explain this. To give you the references, it's paragraph, volume 6, page 457 is CPS's affidavit at paragraph 15.3. And page 377, volume 4, paragraph 94.2 is LASACA's affidavit. And in neither of these can they explain. They say we just don't know. People have moved on. We can't explain. But they don't dispute that this is not in line. So we say that's a major issue. Deputy Chief Justice, I think the other points I would make is that that's just on the profit shifting side. CPS's liquidators themselves have now made clear that retrenchment costs, which are a significant amount, the retrenchment costs were not paid. They say that in terms at CPS's paragraph 18.3, volume 6, page 550, they say the retrenchment costs were not paid. And we know from page 46, volume 1, that the retrenchment costs were 107 million. So that means that already even CPS's own version to this court is that that part of the accounting to this court is at least out because 107 million rands of expenses were never in fact incurred. There was a provision for them, but they in fact weren't incurred. Similarly with BE expenses, which are in the order of 437 million, that appears at page 43. What the liquidator tells this court is that, and I'm reading from paragraph 22 on page 622, volume 6. This is what the Treasury says. Sorry, this is what the CPS, the liquidator says. Treasury can accordingly accept that there is no proof in support of this expense. And then in paragraph 28, the liquidator goes on to say that the Treasury can consider disallowing this expense given the absence of proof, and that appears at page 625. I simply raise those issues quite in detail to say to this court, those are material issues that need to be investigated, we would say, because it means that the KPMG and MZAR reports before you are at least open to serious debate. And that was the very purpose of the accounting exercise. Now, I've spent much longer than I intended, but I thought it was important. I think I still have, do I still have about 5 minutes or 10 minutes? I'm not sure if someone can give me a timing. I think we started a little late.
Only 1 minute.
1 minute, okay. But I thought that was important to spend much time on that because I think it gives a steer to this point. There is a lot of
perhaps to round off properly, maybe let me give you 5, which
okay. I can try and be quite quick, Deputy Chief Justice, because I think the point is this. This court has and has used significantly its just and equitable powers to come to a true solution. And we've in our heads of argument, we've given you the standard references on that, and the court knows the jurisprudence well. I won't waste time on that. So this court has the power to solve the problem. The question is how to use it. And fortunately for this court, I've told this court that it is necessary to give effect to this court's orders and public accountability that CPS's proper profits be known. And in fact, from All Paid 2, in paragraph 70, this court said the public is entitled to know the extent of CPS's profit. That's paragraph 70 of All Paid 2. The public is entitled to know. And it's continually required a proper accounting. That has not happened. I've shown you demonstrably that the facts before this court show that you cannot sit back and say the KPMG and MZAR reports are the public accountability, because they are shot through with there are serious debates about them. Now, it may be that after full investigation, it all turns out to be nothing. But I must say, one doesn't need to have spent much time in this country and in this court, where this court has repeatedly cautioned about the need to investigate such matters and the issues involved, to say that these issues cry out for accountability. But more importantly, we don't even have to go that far. This court has in terms said that it will not stop at CPS's own accounting. It will require a verification by SASA and an approval by Treasury. Neither of those two things have happened. In fact, that process has thrown up the very issues we've raised. But what does the court do? And I can say, having spoken to all of the parties, that in principle, as I understand it, although there may be some debates, at this stage, all of the parties have no objection in principle with the Section 38 inquiry to get to the bottom of this. This court, in fact, gave such an order on the 3rd of December, 2024. None of the parties have a principal objection to that. There may be some dispute around terms of reference possibly, but that's only from Lusaka. CPS in their latest heads of argument says that this court should grant the order as granted in December 2024 on the terms of reference that this court agreed, which were broadly in line with what Freedom Under Law and SASA and RAIN proposed to this court, which basically required the Section 38 inquiry to investigate all the issues raised by Treasury and then and determine those issues. And we would say that is the just and equitable relief. That hasn't yet been tried in this matter. It hasn't been. And none of the parties are objecting in principle to that. And we would say that will give the court the information it requires, because it will answer the very questions that have troubled me and I would submit will trouble this court. Has there been improper profit shifting within the Net1 group? Have expenses that shouldn't have been claimed been claimed? And has there been a shifting of income out of CPS or not? And once those answers are answered by the Section 38 referee, together with expert accountants, which were proposed and this court ordered initially, we say that will be much more likely to get to the bottom of this. And at that point, the court can then consider what then. That was the Acting Deputy Chief Justice. Those are my submissions, and I now submit myself to questioning.
Thank you, Mr. Koutsoudis. You emphasize the fact that the public needs to know, but the need to know, as I understand it, was linked to payment. So it was not knowledge for the sake of it. Now, all indications are that there will not be payment. I won't even say that it's highly unlikely that there will be. Or rather, if there will be, it will be quite minimal. And if SARS comes in, everything will be wiped out. So why this for the sake of it, as it were? Can't a judgment, for example, emphasize the points that you make, but end this matter? When All Pay 1 was decided, that was my first year, my first 6 months on this court. I'm retiring in 2 months' time, and this saga is still continuing. Why should we continue? I understand I may sound like I'm making light of this, because as you argue, and correctly so, this is a a rule of law issue. I do not by any means intend to make light of it, but I'm looking at the realities. Because to get to the point where you want us to get, a lot of money will have to be spent. And to what end in the end?
Sure. Deputy Justice, that's an excellent question. And I think there are two levels of answer I want to give you. The first is the principal answer, and then I want to deal with the practical answer. But I don't want to give up on the principal answer for this reason. My clients, freedom under law, have always thought that accountability wasn't an end in itself, that it was an accountability to this court for profits and to the public, and that thereafter the court would then consider whether repayment should happen. But I want to be cautious with the submission. Justice Froneman in this court's judgment did not say that in terms. It viewed accountability as an initial end to be fulfilled. And it didn't just do so once. It did so in a number of instances. So, I mean, just to give you, I want to just read. So, paragraph 59 of All Paid 2 says, the commercial part dependent on or derived from the performance of public functions is subject to public scrutiny, both in its operations and financial aspects. So this court confirmed in principle that the financial aspects of CPS's work was open to public scrutiny. But it didn't end there. Paragraph 67, the famous paragraph 67, ends this way. But CPS's assumptions of public power and its functions in the execution of the contract mean that, in respect of its gains and losses under that contract, CPS ought to be publicly accountable. So this court said it must be publicly accountable. That was the point. It said public accountability was an end in itself. And then, to the extent that there's a suggestion that I'm misreading All Paid 2, paragraph 70 says the same thing. CPS will benefit from an unlawful contract if another tender is not awarded. In that event, and we know that event occurred, the public is entitled to know the extent to which it so benefits. So there's a public entitlement that this court recognized. And I would say to you, there are 7 judgments which confirm this. So I'm not sure at this point, I want to be a bit bold here. I'm not sure whether at this point the court can in fact say that that's no longer required. As long as you accept with me that there hasn't been a proper determination of the profits. This court cannot say that public accountability has happened. In fact, we have the opposite of public accountability. We have the terrible situation where it's possible that the public has been misled. Now, I don't say that lightly, but I say that if the court were to jump out now, what we would have is the completely impalatable situation that despite the fact that this court has required public accountability, we have 2 audited reports, which were the slimmest things ever. They were a few pages. I remember getting them. They're nothing. They're not full reports. They just say these are the expenses. There's no the background documents are not before the court. Versus 2 90-page plus reports by Rain saying, we don't like this. There are significant problems with this accounting. We have a serious concern. The court will be left with that, and the public will be left with that unpalatable position. Okay, so that's my principal answer. But here's the next one. Merely because CPS is in liquidation doesn't mean that if this court ultimately finds that, let's say, its true profits were R1 billion, not the 252 million. Let's take $1 billion. I like that number. It's round. Let's assume that the profits were $1 billion, which, just to be clear, according to Rain, is only a fifth of the profit that Net1 made. Net1 apparently made 5 billion rands worth of profits off this contract. But in any event, let's just assume only 1/5 of that profit is actually CPS's. What then? Well, I would say there are a few different practical answers. One is to say, and this is the least, and you will like this the least, but at the very least, SASA will get a greater portion of what is left in the pot. Currently, there's 50 million rand in the pot. But we know from the report that Lusaka has, that the liquidators have filed, that in principle, CPS has brought a claim against SASA for a further 350 million. So they have a claim. That would be added to the pot too if they were successful. That would take you up to 400 million. And then even if it only marginally increases SASA's pro rata amount. That would not be nothing. But secondly, and this is where I would say it's not for the court now to determine, but you've asked me and I must answer in this way. It will not be an end in itself simply because if this court were to find, if the Section 38 were to find that there had been improper shifting of profits to shield the accounting to this court and the public, if that's the finding, that would open at least the possibility that either the liquidator or SASA as a creditor may do one of two things. Firstly, they could use the insolvency law under so they could use the insolvency law under a collusive arrangement, Section 31 of the Insolvency Act, to set that aside. If it's true, if indeed CPS and CPS and Net 1 shielded profits in this way, it's possible that could be set aside. Secondly, and this is more bold, but I simply say that this is something SASA can consider. If there is a finding by this court that the 1 billion rand is repayable by CPS, but that money cannot be claimed from CPS, there would, if indeed the true facts are that that there was an attempt to misuse the corporate personality of CPS and shift profits within a group, it would at least be open to SASA to consider bringing an action for piercing of the corporate veil for unconscionable abuse. I'm not saying that the case is made out for that. My only point is this court shouldn't at this point determine that there could be no value, because the facts before you are of significant gravity that it would at least open up the possibility for further remedial options that SASA might consider in the future. I'm not saying that, but my major submission to this court is you don't need to go there, because this court's judgments simply require the number to be known by the public. Those are my lengthy submissions, Acting Chief Justice.
Thank you, Mr. Kutsudi's colleagues.
ADCJ, may I follow up on that? Mr. Kutsudi's, one of the problems in this long-running saga is that there's been a distinct lack of cooperation, and disappointingly so. I mean, I am perturbed by the fact, now I know you can't answer that, but I'm perturbed by the fact that SASA is not represented by counsel here today.
Mr. Mpaha, my brother, Mr. Mpaha is here.
Oh, Mr. Mpaha is here.
He placed himself on record, yes.
Oh, okay.
Yes.
Let me ask you this. Lasaka's case has been throughout that they're not a party to this. They're a bystander. They're a witness. Now, Lasaka and CPS, before its liquidation, denied that there's been profit shifting, and there's a tremendous dispute of fact on documents that have been asked for and documents that haven't been delivered. I mean, Rain says they were not informed about the possibility of making submissions to the insolvency inquiry, and the liquidator says that Rains has been sitting, Mr. Pierce and others have been sitting with the reports for over 18 months and nothing has happened. How do we resolve that dispute about what documents are required outside of Section 38? If we leave aside the Section 38 inquiry for now, how do we resolve that dispute about what documents were required and were asked and were in fact delivered?
Justice Majid, can I say, I mean, I think that is the question that's troubled my team and myself. Justice Majid, I seem to have lost your video, but do I still have you? Maybe I'm losing other videos. Okay, that's fine. So Justice Majid, my view is that, you say outside of the Section 38, I think one of the ways to resolve the dispute obviously is the Section 38, because it avoids trying to get into a debate about whose fault it is, and that avoids that issue. But if the question is, well, what do we do? The proposal we make in our heads, and we've made in our initial heads in this matter, as well as in our further heads, what we say is, well, we have a simple solution, and it's maybe a bit bold, but it's a simple one. We say, look, where does the obligation lie currently? This court's already made that determination. It said that if the Treasury cannot approve what Rain has done, it must determine. It must make the decision. It must make a determination. And then it empowered Treasury to ask what it required. Now, my slightly bold submission to you is that determining the profit of a company is, to use Justice Madlanga's words in the different case, not rocket science. It is not rocket science. It happens all the time, and accounting is absolutely standard in business and before the courts. There cannot be a suggestion that it is impossible for Treasury to determine a company's profits. The only question is, what does it require? If it's information, then it should be given further information. If it's subpoena powers, well, we would suggest, although not necessarily a simple case, but if it needs subpoena powers, those should be given. Or if it says to you, I would prefer you do a Section 38, well, then that could also be an option. But we say the solution then is to say, well, look, there's been so much back and forth. CPS, the liquidator, who's already explained his position, and LASACA must be asked to answer the questions they have. Again, they must be told to file an affidavit with the Treasury, answering all the questions without any dispute about relevancy. No, because LASACA, at least in a few instances, it says we refuse to answer these questions about the BEE costs, and we refuse to answer them in relation to profit shifting. We don't think it's relevant. Well, we say this court has always thought it's relevant. They must answer those questions. If they honestly don't know because people have left the business, then they must say that, and they must indicate on affidavit which people they think have the information. And then Treasury must be allowed to obtain that information from those people, and it must make a determination as best as it can. And we've said this, we don't think perfection should be the enemy of the good. It must make a proper accounting determination as best as it can on the evidence as it's determined. We don't want to have a situation where if it can't get to the bottom of it, just says, well, it throws its hands up. I think that's not possible. The CPS's liquidator has given an indication of what that could look like. It says, well, if there is no proper proof for this expense, if no one can give you any documentary proof that these BE costs were legitimate costs, well, disallow the cost. Disallow it. That's what accountants do all the time. If you don't have the vouchers, you disallow. So Treasury must do that. After good faith, it must be told to make a determination on that basis. And in fact, the liquidators invited such a determination. So that would be our submission, but we have been willing to accept that. And I want to put this cautiously. Mr. Manechi will tell you his views from the Treasury, but can I just say this? It appears that Treasury has never wanted the ball, and it's desperately trying to hand the ball over. And most of the parties are willing to accept that a Section 38 might be a better vehicle in those circumstances, and we wouldn't want to be back here again. So we would prefer, we think it might be wiser to use the Section 38 if that is what Treasury says it would prefer. Because we've always thought that it can ask for whatever it requires. And if it says to this court, look, we have limitations. We don't have subpoena powers. We can't go after all the documents. A Section 38 would be better placed to do the due diligence. Then we would say, well, that's permissible for it to ask that.
Do I understand your
Sorry, my brother. Mr. Koutsoudis, can you please try to shorten your answers from this point onwards? Yes, my brother.
Thank you. Do I understand your answer then to say that although LASACA has never been a party to these proceedings, they can be ordered to hand over documents in this process?
Yes. Justice Majid, can I make 2 points on that quickly? Point one is that they were cited as a party when we brought this application. And we think that that's every interlocutory application, you can always cite new parties if you seek relief against them. In fact, had we not cited them, there would have been a non-joinder because they were identified by Treasury as being the parties that had the information as the parent company, A. B, that's how KPMG, IMZA, and RAIN found themselves before you, because in Freedom Under Law 1, in 2020, that's exactly what we did. And no one questioned that. We added KPMG and IMZA and RAIN because they had information as parties in the same way as we added LASACA. No one's complained. Lastly, I would say to you, I really find it difficult, quite difficult. If LASACA's submission really to this court is that it's a stranger to this process, I find it significantly difficult because it tells this court that during the tenure of this contract, it controlled CPS. It appointed all of its directors. Its CEO and the CEO of CPS are the same, and they've at all times been aware of this process. So I have a difficulty if they suggest they're a complete stranger. And we know from freedom under law judgments that one of the big issues of investigation was profit shifting within the group. But most importantly, there's no prejudice to them. We've cited them from the beginning, and they've made full submissions and filed full affidavits in this matter. So I'm not sure that they can really object to that. And they're not, my understanding is they're not objecting to be joining for the purpose of giving information. That's my understanding.
And then just my second last question, these inconclusive section 417 and 418 proceedings before Judge Joffe, where does that leave us? Does it matter at all?
Well, Justice Majid, my view is that it doesn't matter in this sense. Rain tells us at paragraph 9 of its latest affidavit filed on the 22nd of May, 2025, it says that the issues before Joffe were not the same issues that Treasury has raised. They said almost no questions raised.
You mean Judge Joffe?
Sorry, did I say? Yeah, sorry, Commissioner Joffe. Sorry, I apologize if I misspoke. Commissioner Joffe, Judge Joffe's, the inquiry before Commissioner Joffe dealt with almost none of the issues. Now, I, of course, wasn't present in that. Freedom under law wasn't part of that, so we don't know the terms of reference or whatever. But it appears that the suggestion is that that wasn't the focus. And of course, Rain's affidavit is that much of the inquiry, it wasn't allowed to lead evidence. There was a significant, it wasn't the main focus. In fact, the main focus was trying to test whether or not they had done their job properly, not whether or not the issues, what the answer to the issues they raised were. That seems to be. So I don't think the 417 and the 418 can solve the problem. And even the liquidator, whose process it is, says that they are happy with this court granting the Section 38 order in line with what was granted in December 2024.
Last question, thank you. You may have answered it, but I think I may have missed it. This objection to the wide terms of, I'm back to the Section 38 inquiry now. This objection to the wide terms of reference by LASACA, what do you say about that? And again, if you have answered it, forgive me. I just trying to keep up with bookkeeping.
I mean, my sense is that this court has already said in the Rain judgment that it would be improper to try and start again. And the problem with LASACA's terms of reference is that they are one party's view of a very limited set. They don't include the profit shifting. They basically avoid all the real issues. In fairness, if you go and compare them, they don't deal with the issues that Treasury itself say need to be investigated and Rain say needs to be investigated. Now, the investigation may turn out to be that there's nothing to see here. Perfectly fine. Very happy with that. But the problem with LASACA's terms of reference is that they ignore the big issues. They don't get into the profit shifting issue. And so we say, well, that's not going to help us. And so we have a significant problem with those limited terms of reference. And more importantly, and we've made the submission, our heads of argument. This court is faced with only one expert accountant or auditor. That's Mr. Pierce from Rain. Neither CPS nor LASACA have put up expert accounting experts. They have not. At best, Mr. Blow now says in his heads of argument, well, when they drafted their heads of argument, they talked to an accountant. I'm sorry, but you can't get evidence from the bar in that way. I haven't seen this accountant report. I don't know who they spoke to or what he said to them. It's simply not good enough. The only accountants before this court are the auditors from Rain and possibly the Treasury, because the Treasury's two affidavits are signed by the Auditor General and the Acting Auditor General. So those are the only expert accountants before you. So it would be quite unusual if LASACA tells this court what it thinks the terms of reference of in essence, an accounting exercise should look like. Those would be my full submissions.
I think you meant to say, sorry, Accountant General, not Auditor General, as far as Treasury is concerned.
Sorry, I meant Accountant General. I apologize.
Thank you, ADCJ. Thank you, Mr. Coutsouris.
Thank you, my brother. Colleagues?
Just, may I ask a question? Just a moment. Mr. Coutsouris, if we were to resurrect the Section 38 route, I presume the costs will need to be, I'm not talking about the parties' individual costs, but the costs, the administrative costs associated with the judge. If you know, the judge may need an assistant, a venue, and the like, transcription services, recording services. Will that need to be, who will have to pay them?
Justice Rogers, thank you.
I assume the only parties who who we could plausibly require to pay those costs would either be SASA or National Treasury.
Those are our submissions, Justice Rogers. We've made a proposal in paragraph 34. We've defended that in paragraph 34 of our 25 April 2024 heads, but we say that both of them have a legitimate basis upon which to pay. Our submissions are that SASA, it's SASA's.
I think that's sufficient. You say that one or both of those parties should pay the costs.
Yes.
If when we hear their counsel, those two public bodies say we don't think it is worth spending the money on this, should that affect our view of the matter? I don't know. I'm not sure if you could predict how long this inquiry would take, but if it involves compelling people to give up names and then tracing and calling long retired employees of LASACA or CPS, it's a process that could extend into some time.
Sure.
And of course, I'm not sure if it only involves getting the documents, or if it also involves the further process of determining what those documents indicate and whether there is a larger profit than has been currently certified. But those state parties may say, we don't think we should be required now to spend real money to chase what is potentially phantom money. Will your answer be the same? The rule of law and the need for transparency and accountancy trumps that. We should not pay heed to what those parties think in regard to the worthwhileness of spending money on an inquiry.
I think so. My answer would be yes, with two additions. Addition one is that Treasury currently bears the obligation of making this determination. If it wants to hand over the obligation, then it must pay for that. Otherwise, if its answer is we're not paying for this and that were to stymie that determination, then its primary obligation under 3 of this court's orders, or at least the last 2, must therefore be fulfilled, because Treasury must determine. So they must propose what alternative options, which would in any event no doubt include them having to employ accountants to assist them, I would imagine. But my primary submission is the one you've put, which is if they were to object, then I do think this court could nevertheless order it because of the public accountability issue. And it gives effect to what this court has ordered, which was SASA was always supposed to verify what the profits were. It was always bore that obligation.
So any order we make now is still conditioned by Section 172 as to what is just and equitable, and changes of circumstances may affect what is now just and equitable as opposed to what might have been just and equitable in 2014 or some other date. Is it not relevant that the public interest may not be served by spending a substantial amount of money on determining on paper a larger profit? I appreciate what you say, that we can't yet finally determine that there wouldn't be some real tangible financial advantage in a refund order, given other remedies that might be available. But is it not a relevant consideration that the money needed to chase this, on one view, phantom, is money that the public is having to pay? In other words, is the public interest in knowing what CPS's true profit greater than the public interest in, say, avoiding an expenditure now of 20 million rand or whatever the sum will be? Maybe I'm using an unduly large figure. I don't know.
No. I mean, the question is the correct question, Justice Rogers. It's a very important question. I would say my submission would be that the public accountability. This court has often said that constitutional rights have costs, and that the state bears those costs. And we would say the same applies to public accountability for organs of state. If this court were, if across the board investigations were to be stopped because the possibility of obtaining certain money wasn't likely, then there would be many investigations that didn't happen. And we would say here there's a heightened public accountability issue precisely because what has happened has shown that there's a real issue in relation to whether this court and the public has been misled. I mean, that's the outcome of what Rain is telling you. So you have so SASA's experts have come to this court and said, I think there's a material wrong.
I don't want you to eat into everybody else's time too much. You say that the public benefit from transparency and knowing that the court hasn't been or has been misled, we may take into account that will outweigh the tangible costs that might now have to be spent. It's a weighing exercise we would need to undertake.
And Justice Rogers, can I just add, and SASA will say this, but we'll deal with this, but I don't read either SASA nor Treasury, but certainly not SASA, to be objecting in principle to bearing the costs. I don't understand them to be in principle having a principal objection. Treasury may have their own views on this.
I think Treasury, I think the straw that broke the camel's back on the previous Section 38 process was some squealing from Treasury about that the court hadn't ordered them to pay certain things. A final point. I don't know what you've mentioned the BEE costs and the royalties as two items. I'm not sure if those are the biggest ticket items in the potential cost shifting. And you've also raised that FUL has taken the view that if these costs can't be substantiated, the proper course might simply be to disallow them as costs in the computation of the profit. Mightn't that then be the robust way forward, to say that to the extent that certain expenses have currently been allowed in the audited process as reducing profit, if LASACA and CPS take the view that they cannot substantiate them and that the information now lies beyond their reach, wouldn't the robust and proper course be, I don't know whether this court would have to direct that to happen or whether the National Treasury would simply reach that conclusion on its own, but simply to say, well, we are not going to allow costs that can't be vouched, particularly if there are reasons to question them. You pointed about matters about the timing of the royalties. It's possible that CPS and LASACA could be, as it were, given one final opportunity if it wishes to substantiate them, and any other items that you haven't mentioned in your oral address. And if they can't be explained, for National Treasury either to disregard them or for, I presume there could then potentially be a review of National Treasury's final determination. But wouldn't that be the route to go? Because I don't understand CPS and LASACA. They may tolerate, as it were, go along with the Section 38 process, but I don't gather that either of them are necessarily keen for it to happen. They would rather draw a line. So in a sense, the ball would be in their court. They can either have a final opportunity to substantiate, or they must accept that costs that appear questionable and can't be vouched will be disregarded. We can again hear, when we hear from CPS and LASACA, whether that should or shouldn't happen. But are there any items that you know of that are significant, ones that would be worth pursuing? No, I'm not talking about 200,000 there or 300,000 there.
No,
numbers in the millions that couldn't be dealt with in that robust way.
I mean, it's not, Justice Rogers, I think the short answer is I think some stuff can be, and I think perhaps Mr. Budlender can address you from Rain's perspective, but there are all the major issues that have been required to be investigated, which the terms of reference deal with. The terms of reference list all the major items. Those are all big ticket items. Each of the issues that Treasury has asked are significant issues, not small change. And there's obviously some issues, some of them, there's a debate about whether they can be properly vouched, and others there's a question whether the vouching is legitimate. And I'm not sure all of them. I certainly think in relation to the BEE cost, there's a suggestion of inability to properly vouch, and certainly the retrenchment costs, there haven't been. And my submission was partly to say that even CPS's liquidators suggest that if there hasn't been proper vouching, then costs could be disallowed. But I think I'd go too far if I say that that's the case for everything. So for but also royalties, there are significant questions whether there's a proper a proper vouching, but there is some vouching, and Rain has questioned whether that's legitimate. So I'm not sure it's an answer to everything, but certainly that may be one option to either tell the Section 38 or Treasury that, as you suggest, I think that if perfection shouldn't be the enemy of the good. If they can't properly justify an expense, then it shouldn't be allowed, and that's quite a standard procedure when you're having to do an accounting.
Now one might get information in the sense of personal recollection from people who left the employ of these entities some years ago, but one's not going to find vouchers. Those documents, I presume nobody suggests that those people will be in possession of the documents that will evidence an expense. So what is really the value of interrogating all of those people? I mean, if CPS liquidators and LASACA between them can't produce the documents that will explain something, a view just has to be taken on it. You're not going to get more information.
I mean, I think that's true, Justice Rogers. I would agree to you up to the point of I'm not sure a proper attempt has been made to get the information from everyone who might have it. But I might suggest that it's possible. But I agree with you that at some point there has to be a finding that says, well, if there are no documents to vouch, then we must disallow, or we must at least take a decision whether to disallow. Because you're right, you can't allow a situation where you endlessly look for documents which may no longer exist or have never existed, and then simply not reach a conclusion at all. That can't be right. So I think that must be correct.
Thank you. Thank you, Deputy Chief Justice.
Thank you. Colleagues?
Deputy Chief Justice, if I may. Mr. Kutsudas, this is also just to follow up on a question that was asked by my brother, Justice Majid, in relation whether this court can order any relief against LASACA. We are dealing with proceedings that arise from an order. This court, LASACA was not a party, that they had been cited. Have they been joined as parties? Has LASACA been joined? I'm sorry, is my connection not clear?
Perhaps to improve your audio, if you don't mind,
Yes.
maybe switch off your camera. Thank you, thank you, my sister.
Yes.
Justice Theron, I think I have your question.
Okay, thank you.
So Justice Theron, as I understand your question, what you're saying, has LASACA properly been joined? And I think I've tried to make a submission to Justice Majid on this, and there are twofold answers. One is to say, this application by Freedom Under Law, the second applicant, was an interlocutory application to ensure compliance with court orders once Treasury filed an affidavit with this court saying it needed information, including from LASACA. So we brought an interlocutory at the invitation of this court. We brought an interlocutory to say, well, please hand over that information. And the party identified was LASACA. So it's a classic situation where an interlocutory, you can always cite a new party where you require them for the purpose of the interlocutory. So we did cite them. And that was the process we took similarly with Rain and MZAR and KPMG in Freedom Under Law 1. So we've never had anyone question that. But if we followed a wrong process in the way we did it, we would say that form over substance, the substance must trump, because they have been fully cited, they filed affidavit, they filed heads of argument, they've been represented by counsel. So I don't think they can be heard to say that there's been any prejudice to them in the way they've been joined. And there can be no suggestion that they're an irrelevant party. In fact, they have a direct and substantial interest, because one of the issues is that their information and whether there's been profit shifting from CPS to them is the main purpose of the inquiry that this court itself accepted was what Rain's investigation was showing. So they are a necessary party, and they have been joined the way that we've joined them. And if there's any prejudice, we would say that that in principle there can be no harm to them, because they have been given full opportunity to be heard.
Thank you, Mr. Kutsudas. Thank you, Acting Deputy Chief Justice.
Thank you, Justice Theron. Any other colleagues?
Acting Deputy Chief Justice, if I may, Mr. Kutsudas, if the Section 38 proceedings would be resurrected, are there any time limits in these kinds of proceedings? If not, could time limit be put on them to try and, get to finality one way or the other? What would you suggest?
Justice Mbuza, in principle, a time limit it doesn't have to be set. It certainly wasn't set in this court's order of December 2024, but there's nothing stopping this court. Our submission, freedom of law submissions are, this court is very much in the world of Section 172, 1B powers. And if you think it's just inequitable to rather try and provide timeframes for the decisions to be dealt with and a time frame, obviously perhaps with some ability for the referee to ask for some extensions or something. I think that's completely within this court's powers to provide for that in your order.
Would you be able to guide us? Would you be able to make a contribution one way or another?
Justice Mbuza, it's very difficult for me to do so at this point because my clients are not the expert accountants, unfortunately. So I would be very nervous of making that submission. And what I would perhaps suggest, though there is one option, and maybe this is a little bit too creative, but is the type of order we've proposed, and everyone seems to have agreed to in principle, is that a retired judge is appointed, and that retired judge is assisted by accounting experts. It's possible that those that you could ask as a first step that they make a proposal for how the matter could be expeditedly determined and ask for the court to then issue directions in line with their proposal. Or you could give a direction that the retired judge themselves set timeframes that allow for the determination as in the most expedited way possible, given the issues to be determined in consultation with the accounting experts that are assisting the judge.
Thank you, Mr. Kutsudis. Thank you, Deputy Chief Justice.
Thank you.
Thank you, ADCJ. Just one question from my side. Mr. Kutsudis, accountability is at the heart of the Constitution, and I think it's something that the Constitutional Project must be fully committed to. But sometimes accountability may elude us. Not because of a lack of will, but sometimes circumstances may conspire to push it in a sense beyond our reach. And there are times when I think this case may be something like that, because as you point out in your opening, there are 15 million people that looked towards SASA for the payment of their grants. Those same people continue to look towards the state, same pot of resources for the ability to improve their lives. And if one is in a situation of fine balance and possibly conflict, where on the one hand, we have relative certainty with regard to the financial position of CPS as we know it from the liquidators. And on the other hand, there is perhaps the hope that that financial situation may improve positively, but nothing more than a hope in which is infused the possibility of ongoing litigation, both around the collusive dealings that you speak to, as well as the piercing of the corporate veil. Would you think that it would be showing disloyalty to the principles of accountability and the rule of law if this court were to finally balance those and make a determination that sometimes, indeed, our attempts to hold on to accountability may yield nothing when the circumstances in which we find ourselves prevent that from happening? And I'm not suggesting that it's as simple as saying we don't have the financial means to pursue it, because accountability is not and never has been about the financial ability to do so. But in this case, as you point out, the twin-prong approach was to know the figure for the benefit ultimately of recovering it and making an order for repayment. But if that proves elusive, then what do you say that we may conclude that under those circumstances, we don't breach, as it were, the obligation to advance accountability? It's an important issue because it ultimately will shape, as it were, what message this sends out to the world and to the public at large, and to those who seek to evade accountability. Yeah, I'm not sure the answer to that And it's a long question, but I think it might warrant perhaps a shorter answer.
Justice Colopin, can I start where you ended? And I'll be short, but I'll elaborate if you need me to. You ended with an important point, which is, would we show fealty to accountability where there has potentially been attempts to evade accountability? And I would say, to repeat what I've said already, I would suggest that the public interest, there are certainly instances where accountability or achieving something becomes impossible. But if the thing that we're talking about is the independent determination of a company's profits, I battle to understand how the public could ever understand that that would be impossible or something that can't easily be determined with the will and the means outside of attempts to stop that accountability. Because it seems to me that should be, that those type of accounting exercises happen day in and day out. There are experts that are appointed to do those works day in and day out. So if the answer is that can't be achieved, it would tell one that there has been a malign attempt to prevent that, because that should be a sorry, let me be cautious. Either a malign attempt or a simply unwillingness to do it by some party. I don't want to try and apportion blame, but the point is that would be astounding.
I think let's accept that it can be achieved. It can be achieved at a cost. And if aligned to that, the possibility of a repayment is remote, then is that not a relevant factor? And I just want you to focus on that ultimately. Or you're saying whatever the cost is, it has to be pursued.
Well, Justice Colopin, I'm making, I think, potentially two submissions. My primary submission has always been the court orders of this court required that determination to be made for the public, and that's already been suggested. I wouldn't say that it's whatever the cost, but I'm not aware that the costs are so large that the court didn't always envisage some costs being spent to achieve that. And what's happened is that there hasn't been an achievement of that. And the one thing this court hasn't done is use the Section 38 inquiry. It was willing to use the Section 38 inquiry to get to the bottom of whether a minister lied to this court when there were no money that could be obtained beyond a personal costs order. But it wasn't. We weren't talking significant amounts of money that would be returned. So this court already used the Section 38 in this very matter for accountability where it was potentially misled. And so those would be my submissions on that. And also, I would say this court can't also discount the possibility that the inquiry might allow SASA to do more than simply satisfy itself with the pro rata share in the CPS liquidation for the reasons I've already submitted.
Thank you, ECJ.
Thank you. It doesn't look like there are any further questions. Let us take the adjournment and resume at 11:35. Ms. George.
Thank you, Acting Chief Justice.
Court will adjourn until 11:35. If you exit the hearing, please rejoin using the same link. When you've exited, you're welcome to turn off your video and turn off your audio, and then rejoin with audio and your video back at 11:35.
Thank you. Mr. George, you let me know when my colleagues and all counsel are online.
Justices of the Constitutional Court, all counsel are back online.
Thank you. Mr. Koutsouris, there's just one more question, and there may be a follow-up question as well.
Okay.
Yes.
Yes, thank you, ADCJ. Mr. Koutsouris, it's the question that was raised yesterday in the directions that went out yesterday afternoon. And that is the second part. If this court is to take a robust approach and say that on CPS and SACA's own papers, in other words, the Mazars KPMG audits, there is an amount of some 252,660,000 liable for payment. Can we, and this is of course hypothetically, can we make an order that they be held liable even though a concursus creditorum has been established here years ago? I mean, this company went into final liquidation in CPS in 2020 already. What do you say?
Yeah. Can I, as I've told the acting Deputy Chief Justice, in reliance on the order you've given, I actually have phoned each of the senior counsel for all of the parties, and there is, as I understand it, agreement, including from the liquidators' senior counsel, that none of us believe that the fact that the concursus creditorum has been reached would preclude this court making that order. And that's for a number of reasons, including, most importantly, that before the liquidation, in October 2020, in April 2020, Freedom and Law had already sought this order, and it had been deferred before liquidation, and there had been full submissions, heads of argument by CPS before liquidation. There are a few other reasons as well, but the view is that this is pre-existing litigation on that declaration, and none of the parties view that this court would be precluded from giving that order.
Well, thank you, and I must say I appreciate the fact that you went to the trouble of contacting all other counsels so that we have some kind of indication that there's unanimity. Thank you, ADCJ. I'm covered now. Thank you.
Thank you, my brother. Mr. Mpaka. Thank you again, Mr. Koutsouris. Mr. Mpaka.
Thank you.
Thank you, Acting DCJ and the justices. Apologies for not having been able to log on earlier. We had challenges. Justice Majid, we are here on behalf of SASA. And I must say that I don't want to repeat the arguments that were made by Mr. Koutsouris. And I think in respect of the historical background and also the in-principle arguments that he has made, we are aligned in that respect. And I think what is important and what I think I understood from Acting Justice, Deputy Justice and the justices is that we need to look at what would be the practical approach and the solution in regard to this matter. And our views as SASA is that we were given an obligation by the All Pay 3 that we need to do the verification exercise and thereafter report and hand it over to Treasury for consideration and approval. And I think it is that verification report that has become a problem because, one, it has not been approved by Treasury for the reasons set out in the supplementary affidavit submitted by Treasury. And in that respect, I note also that the liquidators or provisional liquidators and liquidators have raised issues to the effect that they should have provided representations in respect of that report, and they were not afforded that opportunity. And Treasury acknowledged that it was an oversight on their side not to do so, and would submit that when we read the affidavits of the liquidator, it would appear that they are still prepared to furnish the necessary information to Treasury to consider, and would align ourselves with the proposal that was made by Justice Rogers in respect of the fact that probably Treasury can still be given the opportunity to look at the very questionable issues that have been raised in respect of the allegation of profit shifting. To look at that, and I want to agree with Kotsudis when he mentioned the acting Deputy Chief Justice, the fact that you have mentioned that it's not rocket science to determine profit. And I think that it may be a cost-effective measure for Treasury to be tasked with the duty to deal with these issues in respect of profit shifting. We have the view that this allegation or this suspicion should be dealt with so that at least in the interest of all parties, being Lesaka and the parties affected, there should not be any doubt that the matter has been considered and they have been cleared, or Treasury would have been able to say that these were unlawful dispositions and therefore the profit should not have been earned by Lesaka in those circumstances. So we want to submit that Treasury must be afforded that opportunity to the extent that it may need its own resources. It has to provide for the resources internally. And we want to submit that at this stage, it would be a cost-effective exercise for Treasury to proceed to deal with the issues that have been raised. And I want to submit that from the affidavit of the liquidator, they have already committed the fact that they would submit information which they were able to collate during the inquiry hearings. And Treasury should be able to determine from that information whether it can work with that information, whether it would require further information. And I do not get it from Lesaka that Lesaka would not cooperate in respect of making sure that these allegations, this suspicion of profit shifting are not resolved, and therefore cooperate with Treasury in dealing with those. And I think that it would be a more practical approach, rather than to have this court to give a number which it would determine as the profit, only limited to the Mazar and KPMG reports. I would submit that if the number comes from Treasury, or if Treasury comes back and say, we have not been able to do the task, we are therefore limited to this number, and give that number. And I would submit that it be a more practical approach. I note that the liquidator has stated in her affidavit that she has investigated and there are no prospects of recovering any amounts. But it is not clear from that affidavit what actually was investigated, what are the issues, and therefore it is simply a wide, and it is not a specified type of investigation. We as affected parties don't know about that investigation and could maybe have made representations and so on. So I think if that task in investigating the possibility of recovery is given to Treasury to do, and then report back to the court and say, we have done this task, and from this task, we are not able to determine any profit, or there's no possibility of recovery, then in that instance, then they can make a recommendation to this court, and this court then can make the proper determination in respect of the profits. Otherwise, we are not also averse to the question of the Section 38, which we had proposed previously in our heads. And I just want to allay the fears that the SASA is prepared to assist with the costs in respect of the payment for the inquiry. And when we discussed it earlier, we were talking about what Justice Majid or Rogers mentioned in the respect of the period within which this inquiry could be. It could be about maybe 3 months with a possibility of extension if so necessary. And the issue that only was raised was not about the cost, if I understood the letter that was written by Treasury. It was relating to the issues of procurement. And we would then deal with those issues with the referee and agree how best we could be able to assist her and cooperate with her in respect of appointment of any resources that she may want. So I don't think the issue of cost should be a matter of concern. So those, in short, are our arguments. And I want to then say that on the last issue that Justice Majid had raised in respect of the directions that were given, paragraph 1B, we are also agreeable with what Advocate Coursudis has said, that it not be any issue if the court grants that order. Thank you, Justice Matano.
Thank you, Mr. Mpaka. Colleagues?
Acting Deputy Chief Justice. Mr. Mpaka, can I just ask if you know, your client is the major proved creditor in CPS's liquidation. SARS apparently has a large claim, but its assessments have been disputed and its claims haven't been admitted to proof. So your client should have, as it were, the dominant voice, as I understand it, in the liquidation. Is SASA, in fact, playing an active part in giving directions to the liquidator? I raise this or ask this in the light of your comment that the liquidator says that she has investigated matters of recovery from third parties for irregularities or under the insolvency law and has come to the view that there's nothing. I would be surprised that your client is overwhelmingly the largest proved creditor should not know about that. So has your client actively followed and given direction in the liquidation?
Justice Orange, yes, our client has been very active in the inquiry and in the processes. And however, in respect of the issue relating to the investigation, in respect of the prospects of recovery, that issue has not been canvassed with our client. So I would expect that from time to time the liquidator reports to the creditors on the progress of the liquidation, and matters of that kind would be covered. But you say you don't believe your client knows more than what you've now conveyed to us. That is correct, Justice. The issue in relation to the investigation, whether there was an investigation on the prospect of recovery from third parties, that issue we have not canvassed.
You will have seen from Rain's latest explanatory affidavit that, I forget the name of the gentleman, but he says that when he was questioned, all the focus of the questioning of him at the inquiry, at the insolvency inquiry, was trying to show that he hadn't done a proper job, that he hadn't done a proper audit. Now, that surprised me because it didn't seem to me, I'm not sure if that line, as it were, attacking what Rainer did, came from SASA, or in whose interests it was to be raising that. Do you know anything about it? Why Rain should have been attacked, and the adequacy of its audit or investigation attacked in the insolvency inquiry?
I think most of the attack came from Lesaka, in respect of the methodology that was utilized by Mr. Pierce in respect of the investigation, because we had appointed Mr. Pierce from RAIN to do the verification investigation, and they were saying that that was not what the court order had said he must do. He was supposed to do an audit, but the methodology that he had followed was not correct. So it is that those issues that were being canvassed, so that they were saying that the report of Mazar and KPMG should stand because his methodology was deviated from what the court order said. So that was the issue.
I thought it might have been via the SASA. So your understanding is the SASA was represented separately as the shareholder or major shareholder at the insolvency inquiry. Was your client SASA independently represented from the liquidator, or did you have counsel or attorneys present?
There were attorneys present.
And was counsel appointed by the liquidator, or who conducted the questioning on behalf of the liquidator?
The counsel was appointed on behalf of the liquidator to do the questioning.
So the liquidator had counsel, you had attorneys present, and Lesaka was there. There may have been others, but yes. Thank you. Just to give clarity, you said the preferable course is now to, as it were, hand it over to National Treasury. Is your understanding that the liquidator would have wanted to comment on provide comment. Was that on SASA's report to National Treasury, and that is still outstanding, is something that still might happen?
That's correct. I would say that she has complained about the fact that she was not given the opportunity to make representations. And
that's just remind me, representations on what exactly? Whose report?
Representation in respect of the RAIN report on the verification process.
On the RAIN report. And just clarify for me, what is the connection or relationship in your submission between what National Treasury must still do in the future and the Section 38 inquiry? Are you saying we shouldn't pursue Section 38 and simply leave it to National Treasury to receive their input from the liquidator and then take a final view? Or do you say that there should also be we should be reviving the Section 38 process?
Yeah, our first prize is the National Treasury, because I see most of the justices have raised the issue in respect of the costs that may be involved. So we're saying the first prize may be National Treasury, who then must be able to deal with all these alleged profit shifting matters, and thereafter report back to the court and say whether they've been able to investigate and come to a conclusion. In as much as you have already proposed that they may then deal with these issues separately, wherein they can then take a robust approach in respect of whether these profits were supposed to have been made by Net1 or Lesaka in the circumstances.
Do you say that this court, if we follow that court, should be conferring any coercive powers on National Treasury, or should National Treasury simply do their best within trusting to cooperation and then make a call to the extent that it has or hasn't received cooperation? Because part of the problem up to now seems to have been that, at least on one side, there's a view that there hasn't been full candor, and I don't say that that's right, but there have been accusations that there hasn't been full disclosure from a CPS or Lesaka. And if that continues, what does National Treasury do about it? Do you say they should be given some coercive power to call in people to answer questions, or should they just depend on cooperation?
I think maybe coercive power, so that they don't have to come back to this court again to say there's no cooperation, but they should be given necessary effective measures for them to be able to get cooperation from necessary parties.
And the alternative to that, it seems to me, might be to say that to the extent that they don't get the cooperation that they feel is necessary, they will just take a robust view on the issues where they feel they lack information. That would be an alternative approach.
That would be an alternative approach, and they must just take a robust decision in respect and make a finding to this court.
Yes, thank you, DCJ.
Thank you, brother. Any colleagues?
Hey, DCJ, please, just follow up just briefly. On that question of the coercive powers, you see, Mr. Mpaga, and apologies, I saw on the initial list that your name wasn't there, and then I didn't look at the updated list of counsel. I made no disrespect, Mr. Mpaga. Just an oversight.
Thank you.
When you talk about the coercive powers, the problem here is that there's a dispute about what documents are required, and B, whether they have been handed over. I'm not talking about relevance at the moment. Are you saying the coercive powers would make provision for that kind of dispute between Lesaka on the one hand and SASA and Treasury on the other, and RAIN also? And if that doesn't help, then you say they should simply take a robust approach, Treasury, because that is what has brought us to this point in this hearing in the first place.
Yes, I would submit that Treasury must take a robust approach, because otherwise there would not be any finality. And I would submit that, as I've indicated, I don't think Lesaka would want to bear this suspicion that it was involved in profit shifting. And I think from their side, they should be able to cooperate to make sure that this negative allegation is dispensed with. And But in case that they don't cooperate, then Treasury must be able to say, we've afforded you an opportunity to provide us with explanations in respect of these transactions. And if they don't cooperate, therefore Treasury must be able to make and take a robust decision, having afforded them an audit on these matters.
And if you talk about coercive powers, do you include by that powers of subpoena and subpoena duce tecum, or what do you have in mind?
I would submit that if they are given powers of subpoena and also the production of documents, I think that would assist. I think my colleague from Treasury, if is aligned with me, he may be able to expand on which powers may assist them.
Thank you, ADCJ.
Thank you, my brother. Colleagues, Mr. Mpacha, it looks like there are no more questions.
Sorry, DCJ, may I?
Yes,
sorry,
yes.
just one thing. It's really just a question. How, assuming that we were to do that, how would that differ, really, from effectively a Section 38 proceeding?
I think there won't be any difference, Justice Hussein, between the two proceedings. The only issue that I had a concern being raised, that we may find ourselves having spent another 100 million with these proceedings, or 50 million. Only at the end, we find that there is no residue left in respect of what should be given to SASA. So I would say that it may be a cost-effective exercise from Treasury's point of view than the 38.
Thank you.
Thank you, colleagues. Thank you, Mr. Mpacha.
Thank you, ACDJ.
Mr. Maneche.
Thank you, ACDJ, and Justices of the Court. For Treasury, our instructions on what submissions to make to the court relate to the Treasury's preparedness to comply with the previous obligation imposed by court order. And secondly, what it says in relation to the Section 38 inquiry. And we may make some submissions in relation to the possibility that there may not be recovery in the end, whether that is a relevant factor for the court to take into account in determining what would be an appropriate remedy going forward. In respect of the first obligation on Treasury under the court order to approve the accounting or to determine the profits if it couldn't approve, Treasury did comply with the court order and provided the affidavits, the two affidavits which were filed, identifying the information that it required in order to complete the determination of profits. Treasury is still committed to complying with that court order, provided the information that it requires can be provided to it to enable it to complete the function. And in that regard, we note that there hasn't really been any real debate that Treasury doesn't require the information that it has requested for purposes of concluding the determination. So, contrary to what my learned friend, Mr. Kutsudi's intimated, Treasury is not coming to court asking to hand over the ball, so to speak, to a Section 38 inquiry. The only reason that Treasury has not completed the task, it's because it is limited by the information that it hasn't been provided. If that information is provided, then Treasury will complete the task. We've had our learned friend, Mr. Mpacha, that the liquidators may be committed to providing that information. We'll hear from the liquidators, and if at the end of the day the court is satisfied that there is such a commitment and that information will be provided, and there is a way in which the court can enforce compliance with that obligation to provide information, coupled perhaps with proper guideline in the court order granting Treasury a clear discretion to say you were given the opportunity to provide information. If there is information not provided on specific items, Treasury can take certain decisions. The robust approach that has been put up, I think together that might enable Treasury to complete the task. I'm not certain about the coercive powers that I have not conversed with Treasury, the nature of the coercive powers that it may be able to exercise, including the ability to resolve disputes if there are disputes. That might still require the court to make final determinations if there are disputes and they are in an area where Treasury cannot legitimately take a robust approach that there has been a failure to provide information. But information is provided and there is still disagreement between Treasury and the liquidators or CPS and SASA as to the sufficiency of the information provided. So that's the one aspect which relates to the continuing obligation to determine the profits. In relation to the Section 38 inquiry, as has been submitted, Section 38 has been submitted as an alternative to the obligation that has been imposed on Treasury. When it was previously raised, and Treasury says that in its submissions, it did not object to a Section 38 inquiry, nor does it object to a Section 38 inquiry. All it didn't participate in is in working out the terms of reference, because in its view was, if the matter goes to Section 38 inquiry, then it vacates its office, so to speak, from the need to be the one to determine the profits, and a Section 38 inquiry would take its course. And it raised the issue about the costs of the Section 38 inquiry, and the submission made by Treasury is SASA is the organ of state that ultimately got us here, awarded the contract unlawfully, and it should carry the cost from its own budget allocated to SASA for the cost of the Section 38 inquiry. But to the extent that the court disagrees and holds that Treasury should contribute to the costs together with SASA, what Treasury asks is that the court at least sets clear parameters as to what level of contribution, and as well as the time frame for the anticipated Section 38 inquiry. There's been a suggestion of about 3 months and so forth. The Treasury doesn't have insight as to what a period may be appropriate to think of in respect of the Section 38 inquiry, but it would require some parameters so that it doesn't face audit issues in relation to the expenditure towards a Section 38 inquiry. The third issue is whether the fact that the liquidators have said, the liquidator report indicates that there may not be money available to pay any profits ultimately determined, whether that is a relevant factor. From Treasury's perspective, it is a relevant factor that the court must put in the basket when it weighs what would be just and equitable, because there is a lot of pressure on the fiscus, and what is in the public interest must also be impacted by that. It's the same. The people that depend on SASA are equally impacted by the money that will be spent on an inquiry if that inquiry doesn't yield anything ultimately. So it is in the weighing, but we wouldn't say that it necessarily trumps the importance of accountability. It's ultimately how the trade-off should pan out. Other than that, I have no further submissions unless there are questions. I did say to the ACDJ that I wouldn't need more than 10 minutes, but that's subject to questions, of course.
Thank you, Mr. Manager. Colleagues? There are no questions for you.
Mr. Manager, sorry, ADCJ. Mr. Manager, I just want to get clarity. Because ultimately you would have seen with the directions that came and went out, that ultimately what halted the Section 38 inquiry route was this queries raised by Treasury. Now, are you saying that if the court stipulates in a Section 38 inquiry what time frame there should be for completion of this work, for example, 3 months, that can be extended by the request of the Section 38 referee, and set a parameter of, say, for example, 50% of costs must be borne by SASA and 50% each by SASA and Treasury. Would you say that Treasury would be prepared to move ahead with the Section 38 inquiry on that basis?
I think what Treasury has said, and you'll find that at paragraph 16 of the written submissions of 2 May, is that if, despite its protestations, the court ordered Treasury to co-fund the Section 38 inquiry costs, the National Treasury requests the court, in its discretion, to clearly define the scope and parameters of such an appointment and related costs, as well as the extent of the National Treasury's responsibilities in this regard. This will assist in preventing any adverse audit findings related to non-compliance with procurement procedures. I understand that to be an instruction that I can say to the court. If the court were to go in that direction, Treasury would comply with such an order by the court.
And absent coercive powers, I'm going back now to asking Treasury. I'm moving away from Section 38 referee. Absent coercive powers, I'm just postulating this scenario. Absent coercive powers to Treasury, how does Treasury then deal with a situation where one of 2 scenarios occur? The SACA says, we do not have the documents that you request and we cannot find them, A. Or B, Lasaka says the documents are not relevant for the mandate that you've been given by the court. How do you deal with that absent coercive powers as Treasury?
That's correct. Without coercive powers, it would be difficult for Treasury to compel Lusaka to provide the documents. But what is unclear is whether giving it coercive powers to compel production of documents would entail giving it powers to determine whether the documents, to make a determination that the documents are relevant, despite the contrary view by Lusaka. In other words, determine it as make an administrative decision in relation to that. If it's given those powers to determine that documents were called for, in Treasury's view, those documents are relevant, and Lusaka disputes the relevance, Treasury is empowered to make the determination, final determination that they are relevant. They should have been given. If they are not given, Treasury can take a robust view on whether the item of cost should be allowed or disallowed. If the court were to delineate those powers and confer them on Treasury, which, as I understand it, currently doesn't have such powers, then Treasury might give it effectiveness to deal with the determination of profits where there are difficulties about relevance of information or failure to provide information.
Well, as I understand it, what was being postulated earlier when we debated this with Mr. Kutsudas is that the court would, in theory, be expected to make an order that when it comes to the question of relevance, Treasury must have the powers to decide that it's going to take a robust approach. If they say they don't have the documents, then if Treasury is satisfied that that is so, or that is untraceable, Treasury makes that call. But more importantly, if there's a dispute about relevance, Treasury takes a robust approach and say, we say it's relevant, we want the documents, and absent, if they persist, then absent the production of those documents, Treasury will then say, we will then disallow this particular expense. For example, I'm not saying it's going to happen, but that is just what I think we have in mind when we talk about a robust approach. Is that how you understand it? And would that be adequate for Treasury's purposes?
That's how I understand it, and I think it would make Treasury's function more effective in that it wouldn't have to come back to court each time there is an issue about the provision of a document or dispute about relevance of a document come to this court to determine that issue and go back to complete the exercise. That would make the function more effective.
Thank you. Thank you, ADCJ.
Thank you, my brother.
ACDJ, can I come in here? Mr. Manechi, on the Section 38 inquiry, I know the previous directions that the court gave the referee fairly wide terms of reference to investigate. I'm just looking at it: retrenchment costs, intergroup royalty fees, profit earned, etc. And in your submission, you said that if the 38 idea was resurrected, then effectively the determination of profit would pass from National Treasury to the referee. Now, the function of a Section 38 referee is to report to the court. The referee doesn't decide the matter. The referee reports to the court, and the court then decides to accept the report in whole or with variations, or can remit it for further inquiry. So if the referee's job was ultimately to determine the true profit, the referee would, as it were, prepare a report. That would come to court. The parties would have to be heard, and the court would then have to determine the profit by accepting the referee's report in whole or in part. Ultimately, the responsibility would be shifted to the court via the referee. There is a more limited form of Section 38 inquiry, and that is one that is solely directed to ascertaining whether further information and documents exist and finding out what they are, not to determine the profit, but to, for example, to call in, potentially subpoena some of the employees who've left, assuming they don't cooperate, hearing evidence to the extent it's necessary as to whether further documents or information do exist within LASACA or within CPS. And the sole function then of the referee would be to report to the court, I have ascertained that the following information and documents exist and have been furnished. I have satisfied myself that information on the following matters, that no more information can be supplied. The court would then potentially accept that, or after, if necessary, hearing the parties, and then refer the matter to National Treasury and say, this now represents the sum total of the available information. You determine the profit. Because it seems to me at this stage, what's in dispute between the parties is not what the ultimate profits are, but whether more information and documents exist to determine what the profits are. And a Section 38 referee could have that limited term of reference, and then it seems to me wouldn't require to have an expert accountant sit with him or her. It would simply be a document and information exercise. Now, I don't know, we'll hear from CPS and LASACA as to whether, and the other parties perhaps, as to whether that is needed or whether that can still be achieved through cooperation. But if it can't be achieved through cooperation, then it's not going to help to ask National Treasury to do it, because there's no reason to, the parties are, without coercive powers, the parties aren't going to then cooperate with National Treasury, or they will be locked on, that they will be irreconcilably apart on whether the information does exist and whether they can supply anything more. And then it seems to me somebody with coercive powers has to be able to investigate whether there are documents and whether there are people who can give more information and just collect it.
Yes, it sounds that would
leaving National Treasury to ultimately determine the profit when that process is done.
Yes, and that might obviate the need to consider giving National Treasury coercive powers. In other words, Treasury determines after the limited role Section 33 inquiry has gathered whatever remaining information Treasury has identified and produced a report on the strength of which Treasury...
It's either that or we would have to give National Treasury some coercive powers, not necessarily as extensive as a referee, but at least some, to be able to get further information and potentially call. You know, SARS has powers under the Tax Administration Act to have an inquiry, to call people in to be interviewed. I'm not sure why National Treasury shouldn't have the power to call people in to be interviewed. I'm not sure whether they would have to be interviewed under oath, but maybe that wouldn't be necessary. Preferably, rather than have a Section 38 inquiry, if one would at least want to consider whether National Treasury couldn't be given tailored powers to go just beyond resting on cooperation, including particularly the power to interview.
Yes, that could be the first option, but I thought the second option of having a limited Section 38 inquiry that is simply gathering, if I can put it like that, gathering information and providing a report which the court, either the court or case, approves to hand over to the Treasury to determine the profits, or which is handed by the inquiry to Treasury to determine the profits.
Either way, it seems to me what we shouldn't resurrect is or this, I speak just for myself prima facie, a Section 38 process which involves a referee determining the profits. Yes. Because I can understand that would entail quite a lot of further expert evidence, and there's no reason why that ultimate task should pass from the National Treasury to a judge.
Yes. That and leaving Treasury with the current reliance simply on cooperation seems to have limitations, and having a referee that determines the profits, so one can have a combination or something in between.
Thank you.
May I just ask a question which builds on what Justice Rogers just was towards the end? Mr. Minachi, you've had sight of Mr. Smith, the counsel for the liquidators, the supplementary written submissions, which are dated the 16th of May. Mr. Minachi?
Not sure that I can readily quickly. Oh, yes, I have 16th of May. I do have them.
All right. Now, he says this in various places in the written submissions, but in paragraph 27, he then says that the liquidator has said in affidavits that she can provide no more information. And then he concludes in paragraph 34, the final sentence, National Treasury has not asserted in any correspondence that the liquidator has not provided what she could. So would you like to respond to that assertion? Because I really want to understand if the inquiry is now moving to, or if it's not going to be an exercise in determining the profits, but rather in an exercise of getting documents and information. Yes. These entire written submissions, it complains about the lack of cooperation between the liquidator and National Treasury, and all the attempts that have been made to try and cooperate and provide information. And then it says, there's not in a single piece of correspondence has there been an averment even that the liquidator has not provided what she could.
That can't be correct, because Treasury's affidavits set out chapter and verse of what has not been provided. If the liquidator was willing and able to provide that information, they would have provided the information.
But she says she's provided everything she has.
Well, I mean, that's, well, yes, I mean, that's what the liquidator says. If in their submissions they say there's nothing further to be provided from the liquidator's side, that would immediately put into question what my learned friend, Mr. Mpaka, believed, that the liquidator is prepared to cooperate and provide information. If the position is that there's no more information to be provided, I suppose they should confirm that position to the court when they make submissions on whether the view of the liquidator is, having looked at what Treasury asks for, there is any information that they are able to provide or not, and whether they are, if there is information, they are prepared to provide that information.
Thank you.
Thank you, Justice Opperman.
Thank you, my sister. Any other colleagues?
A quick one from my side. Thank you, ECJ. Mr. Manechi, I just want to get some clarity. You say if the court were to audit National Treasury to co-fund what we might call, to use Justice Rogers' words, the wider Section 38 inquiry, you would do so with under protest. Is that right?
Yes, that is under protest, and it's linked to the submission we made.
No, I understand that, because really your responsibility was very different from the 38 inquiry.
Yes, quite.
And you're willing to undertake the narrow responsibility at your own cost, but when it comes to the wider responsibility, it's a different ballgame. Correct.
Yes. So
but you're willing to undertake, the sort of narrow inquiry, correct?
Yes.
Not under protest.
The narrow inquiry, yes, the continuing one under court order is Treasury wants to continue that if it gets the information that is requested for, and the court assists it in further providing guidance on what it can or not or cannot treat robustly, or given any appropriate coercive powers as has been raised by the court. That it is prepared to undertake under the court order. There's no.
Then just one question arising out of that. As I understand the structure of National Treasury, investigations, interviewing, etc., really is not part of its character. It manages budgets, it runs the finances, it sets policy. You have no concern that undertaking this task might blur, as it were, what the role really is of National Treasury, because it plays a very important role, and it's well respected in that sense, because it plays this role almost above politics and everything else. You're not concerned that giving it these investigative powers in resolving an important dispute doesn't carry with it adverse consequences for, as it were, the integrity of National Treasury going forward?
Let me start this way. In respect of the narrow mandate which Treasury is prepared to undertake, even that, it is said, is not part of its normal functions, but understands that these are exceptional circumstances where the court requires the assistance of National Treasury to give effect to a just and equitable remedy. That I would say make the same submission in relation to the latter question, that there may be unforeseen consequences or impact on the way Treasury is perceived when it has to exercise the kind of coercive powers that the court has put as an idea. And quite frankly, I haven't taken instructions and think about with Treasury whether the extent to which giving it the kind of coercive powers that are proposed might impact on its normal functioning and how it's seen in the context of the constitutional arrangement performing this function. Perhaps I could simply take an instruction, and when it's appropriate during the course of the hearing, come back to give a contribution on that with the benefit of instructions. It's not something that we canvassed with Treasury at all.
Thank you, Mr. Manager. Maybe it's part of national service, but you can take the instruction in. Okay, thank you.
Yes, I wouldn't like to simply say I don't think there will be a risk, and then as soon as I drop the call and get get reprimanded for that, I would like to be certain that the position conveyed is consistent with how Treasury would perceive itself.
Thank you, Mr. Manager. That sounds fair. Yeah.
Thank you, my brother. Colleagues, thank you, Mr. Manager, Mr. Badlender.
Thank you. As a court, please.
Acting DCJ and members of the court, members of the court will have noted that from the outset, RAIN has said that it abides the decision of the court with regards to the application instituted by FUL. We are in a slightly tricky position because what we have to say and our experience bears on some of the questions that have been raised, so that in the hope that it will be of assistance to the court, RAIN will make submissions on 4 matters. Firstly, what happened at the Companies Act inquiry? The questions have been raised about that. Secondly, the relevance of the financial position of CPS. Thirdly, if there is to be further inquiry, by whom and how, in the light of experience so far. And then fourthly, if I may make some remarks about the cost of accountability. Firstly, as to what happened at the Companies Act inquiry, as the liquidators have reported, the inquiry concluded 2 years ago in June 2023. RAIN indicated that to the liquidators who managed the inquiry that it wished to make written submissions for consideration by the Commissioner, but despite request, it was not informed when such submissions would be due. And it seems likely that no submissions were filed by anyone in the light of the fact that there's been no report. Mr. Pierce was summoned and gave evidence to the Commissioner over several days. He was not questioned by the Commissioner or by anyone else about the issues raised in the proposed terms of reference, Section 38 terms of reference. Those weren't addressed. He was questioned, he says, principally about the credibility of his reports, and it was suggested to him that he was not independent, and it was put to him that what he had done was not in fact an audit. That was the nature of the inquiry. He was questioned principally by counsel for the liquidators and for SASA. I'm not aware that he was questioned by anyone else. I haven't read the whole of that record. The liquidator has told the court that she has provided National Treasury with all of the information which was obtained through the inquiry. But National Treasury says, despite this, that it's still not in a position to approve the updated RAIN report, and that it doesn't have the information it requires in order to make a determination of the profits earned by CPS. It says, in fact, that the vast majority of the information it requested has not been provided. That's at page 599, paragraph 13. I don't understand it to be the position of National Treasury that it contends that the liquidator is holding back information that she has, but it says that the questions which it raises have not been answered. But I don't understand as a contention the liquidator has concealed information, for example. Then to come to the second question, the financial position of CPS, what is clear is that the claims which have been proved against CPS substantially exceed what are called the uncontroversial assets of CPS. And the liquidators state that they've investigated the prospects of recovering amounts from related or third parties on the basis of voidable dispositions and other irregularities, and they say there are no prospects of recovering any such amounts. But that, with respect, begs the question. It begs the question of whether Lusaka, the holding company of CPS, received payments from CPS or as a consequence of the contract to which it wasn't entitled. That's not a matter which has really been properly investigated. To say that there's no prospect of recovering anything first requires an answer to, well, was there any shifting of profits? Was there any permissible receipt by Lusaka of money which was actually due to CPS? Did CPS make payments to Lusaka which weren't due to CPS, due to Lusaka on an arm's length basis? Did Lusaka receive from other parties money which was properly due to Lusaka? Did Lusaka receive from other parties money which was properly due to CPS? And did other entities in the Lusaka group receive monies which were properly attributable to CPS? All of those are the questions which remain unanswered. And if there was profit shifting, then we submit that CPS has a claim against Lusaka for those amounts, or claim against the other entities in Lusaka. And if in that event, the assets of Lusaka the assets of CPS would be very substantially increased. And those are the matters which the proposed Section 38 terms of reference dealt with. It dealt with whether they truly dealt with each other at arm's length and whether the payments which were made were legally and properly justified. Because if Lusaka was taking money which was due to CPS, that was unlawful. If Lusaka was making charges to CPS which were unreasonable, that was unlawful. It was impeachable. These are the matters which are raised in the Rain revised report. They were part of the terms of reference contained in the initially proposed directions of the court. And we make this submission that if on examination Rain's concerns are found to be justified, in fact, even if only a few of them are found to be justified, then there may well be a very substantial excess of assets over liabilities in CPS. At the very least, there will be a very substantially increased benefit to creditors because money will be due to CPS, which is currently sitting in other hands. The largest of the creditors is SASA. SASA has a claim for between 600 and 700 million rand, maybe more than 700 million rand. Any benefit to SASA will benefit the recipients of social grants. And in our submission, if I can ask the members of the, I'm not going to take the members of the court there, but I ask the court to have regard to our submission of the 10th of September, 2024, in which we identified the matters, the specific matters which we submitted require investigation. We dealt with them one after the other from paragraphs 20 to 65 of those submissions of 16 September. And they raised specific questions inter alia with regard to the following. Firstly, intergroup royalties, to which Mr. Coutsoutis referred, they totaled 1.75 billion rand. The questions were raised with regard to other amounts which CPS paid to entities within the Lusaka group. Those amounted to 242 million rand. That's at paragraphs 31 to 36. They raised questions with regard to the sharing of interest between Net1 and Gridrod Bank and whether that interest wasn't actually due to CPS. The amount of that is unquantified, but it must have been a very large amount. They raised questions with regard to the BE costs, to which Mr. Coutsoutis referred. The BE costs, which were attributed to CPS, were 437 million rand. Those costs were in relation to a contract which the liquidator's report was apparently never implemented, 437 million rand. And the liquidator says that this expense, quote, appears to be without supporting evidence. So why was that 437 million rand paid by CPS to Lusaka? Was that a legitimate expense? And one can ask a further underlying question, to the extent that there were BE expenses, weren't they really expenses attributable to Lusaka rather than to CPS? All of those are questions which are raised by Rain. Then there was expenditure in respect of matters which weren't incurred in terms of the SASA CPS contract. That was 129 million rand. Then there were legal expenses in relation to an investigation by the US Department of Justice and the Securities Exchange Commission, 95 million rand. So those are the very substantial sums of money which are an issue. And the question is whether those monies were properly paid by CPS to Lusaka, or whether they were properly received by Lusaka from other parties. And we make the submission that with the greatest respect, it doesn't really help to say, well, they're disallowed. The question is, what would be the consequences of disallowance? If all it results in is a larger deficit in CPS than would other be the case, a larger deficit or a smaller deficit in an insolvent company, it takes one nowhere. The question is, what would be the consequence? And we submit that these matters need to be investigated, because if only a few of them have substance, and if they have consequences, that's the big question. What consequences? If they have consequences, that would make a substantial difference, A, to the true financial position of CPS, and B, to the payment that the creditors, including SASA, will receive through the distribution. If there has been an impermissible shifting of profits, there needs to be a finding that that was the case, not simply a global estimate of profits which were made. So, do we say that if there were monies wrongly appropriated by Lusaka, they would need to be repaid by Lusaka, because the payments would be impeachable on a variety of grounds. A simple statement that the profit wasn't X, it was Y. It wasn't 250 million rand, it was 1 billion rand, it was 2 billion rand. Doesn't take one anywhere if CPS doesn't recover what it could recover or might recover from Lusaka. And so we submit with respect that when the liquidators say that the inquiry that nothing can be recovered from third parties, that begs the question, or puts the cart before the horse. The purpose of the inquiry is to discover whether, in fact, there are payments which were unwarranted, unjustified, and impeachable. And so we submit that the proposed inquiry would serve two purposes. Firstly, it would serve the purpose of achieving accountability and transparency, which this court has said is necessary with regard to the income earned and the profits made on the unlawful contract. That was addressed by Mr. Kotsudis. I'm not going to repeat what he said. Secondly, it may well result in a substantial benefit of the creditors of CPS, including SASA, through the recovery of money which was wrongly paid and appropriated, because those transactions may be impeachable. And we say that it's not possible without an inquiry to know whether there will be such a benefit, and if so, in what amount. So that brings me to the question then, the third question I said I would address, which is, if there is to be a further inquiry, who should undertake it? National Treasury has said on the record that it doesn't have the necessary information to enable it to undertake the inquiry. We can't see with due respect to National Treasury, that any very much will be required achieved by trying to panel beat National Treasury into a body which undertakes inquiries and investigations. and requiring it then to do the exercise. It's not what it's set up to do. It's not what it has the staff to do. And it would, in any event, have to hire people in to do it. I make that submission not on the basis of any evidence which is before the court, but on the basis of what we know about what National Treasury does. It doesn't do this sort of thing. It would probably have to hire people in to do it. Would probably have to hire auditors in, or would probably have to hire somebody else in to conduct the investigations and the interviews and so on. I submit that with respect to what Justice Colopin suggested is actually correct. This is not what National Treasury should do, not what it does, and there's no logical reason for requiring it to do it in this case. It will be necessary for reasons which have already been discussed in the submissions made by my colleagues. It will be necessary for whoever undertakes this exercise to have effective powers of compulsion. And I say that because LISACA, which is a key role player, has made its position clear. And can I say, it doesn't matter whether it's properly joined or not properly joined, information will be, if these questions are going to be answered, information will have to be obtained from LISACA, whether or not it's been properly joined in these proceedings. Can I take the court to the LISACA supplementary submissions? It's called LISACA Technologies Supplementary Written Submissions in accordance with the directions dated 5 May 2025. It's a 6-page document. I'd like to refer the court to what LISACA says on the very last paragraph, paragraph 13 of its submissions. The submissions are dated 16 May 2025. And I'll read it, quote, LISACA remains willing, to cooperate in any information gathering process into the determination of the profits of CPS, provided that the request made is relevant to the determination and are on reasonable terms. And so LISACA tells you, we know what LISACA's position is. LISACA says that the profits made by it are irrelevant. It says it's not going to disclose those. It's refused to do that. It says that its transactions with CPS are irrelevant. It's not going to disclose those. What it says in its heads of argument, its submissions, very frankly, that it's not going to provide material which is not relevant. And so we know that if the National Treasury, for example, knocks on the door of LISACA and says, please give us the following information, when it comes to LISACA's profits and those transactions, LISACA will say, no, it's not relevant. We've always told you we're not going to give you what's not relevant, and we will decide what's relevant. So there has to be a power from somebody to decide what's relevant. And that can't be LISACA, can't be judged in its own cause. And so either one has to have National Treasury given the power to decide what is relevant, or it has to be a referee appointed under Section 38 of the Superior Courts Act, which says, I require this information to carry out my inquiry. Because otherwise, what is ahead, you can, as sure as anything, that if National Treasury says to LISACA, please give us the following information relating to the royalties, or in relation to the BEE transaction, or in relation to all of these things where you made a substantial amount, you took in a substantial amount of money from CPS, the answer will be it's irrelevant. So and then there will be litigation about relevance, and then we'll really be down a rabbit hole. And so that's why it seems to us that a referee under Section 38 of the Superior Courts Act is the person whose task it is. It's a process designed to achieve the collection of this sort of information, particularly where it relates to accounting matters, which this does. It will be helpful to the person conducting the inquiry to have advice from an expert auditor and assistance from an expert auditor, because a lot of these are auditing questions about where should the expense properly be attributed. Is the expense properly attributed to CPS or to LISACA or to someone else? And so we submit that it seems to us that a Section 38 inquiry is tailor-made. A Section 38 referee is tailor-made, or can be tailor-made to deal with the matter, because we respectfully agree that there is a need to ensure that there's no undue delay. That really relates to what timeframes are set, and particularly about the manner in which the inquiry is conducted by the Section 38 referee. We submit that it has to be on an inquisitorial basis, because otherwise we'll be down another rabbit hole of a long trial-type procedure, judicial-type procedure, which will go on forever and ever, witnesses cross-examined for days on end, and no ability to get to an end of it. The acting Deputy Chief Justice and I both have personal experience of an inquiry which went down that route. It was frustrating to everyone involved. It has to be explicitly inquisitorial, that the referee will ask questions and will require answers to those questions, may question the people who answer those questions. There must be a right to a fair process, obviously, but it has to be run and directed by the referee. If it's not, it's going to go down a rabbit hole. We're going to have a long commission of inquiry, which will be inconclusive, and which will frustrate anyone, and which will then cost a great deal of money. That's what costs a great deal of money, is when inquiries of this sort are allowed to run forever. So we submit that if it is done on an inquisitorial basis, there is a reasonable prospect that it can be done with limited expense. SASA has appropriately said that it accepts that it has the primary responsibility for it. National Treasury may, if necessary, share the cost. It is part of SASA's job, and SASA will, in the end, if the process results in a recovery, SASA will be the beneficiary of the process. So then, finally, before I reach my conclusions, something on the cost of accountability. I accept that the court has to undertake a weighing and balancing exercise as to what is just and equitable. But I want to point, if I may, to what I submit are three weighty considerations in this balancing. Firstly, the point made by Mr. Koutsoudis, the importance of the principle of accountability, which was enunciated in this very case, in all pain. Secondly, that successive orders of the court, of this court, have not in fact been complied with. I'm not saying that there's been a willful non-compliance, but the fact is the court has made orders which haven't been complied with. That's a rule of law issue. And thirdly, there is a material prospect of recovering money for the benefit of the public far in excess of the cost of any reasonably conducted inquiry. The amounts involved are very, very large. They run into literally billions. And so there is a prospect of recovery which is substantial. I don't say it will be recovered. No one can say that now. But what we respectfully urge would be unhelpful, would be for the court to say, well, with or without the assistance of National Treasury, to say, well, we see that the auditors, Mazars and KPMG, said the profit was 252 million rand. On robust, we say it was 1,252 million rand. That has no consequence. It stands there in the air. CPS still can't repay its creditors. So it can't pay its creditors. So it's a finding in the air, and accountability doesn't exist in the air. There has to be something which will deal with the question about whether there's been cost shifting, as the RAIN report suggests there may well have been. Then finally, Acting Deputy Chief Justice, in conclusion, this case has come a very long way. It has occupied the attention of this court on a number of occasions, and the court is, we all appreciate, heavily overburdened and has many other matters it has to attend to. But we submit with the greatest respect that this would not justify bringing the matter to a stop. I haven't really heard that suggested in the debates. We say that make the following submissions in conclusion. Firstly, at the very outset of this matter, this court drew attention to the need for transparency and accountability in respect of the profits made through the implementation of the unlawful contract, including the court-ordered implementation of the unlawful contract. Secondly, I remind us, if I may take the liberty to do so, that the court succeeded in pulling us back from literally a catastrophe, imminent catastrophe, when it decided the first black Sash application, because without the intervention of the court, literally millions of people would have been without social grants. Looking back, I have to say, reflecting now after these years, it's difficult to remember or even believe how close we were to that catastrophe. The court intervened and it saved us from that catastrophe. We submit, thirdly, the requirement of transparency and accountability, which the court emphasized in all pay, have not been satisfied. Fourthly, that there is a means available to the court to ensure that it's achieved, which is a section, I suspect, a Section 38, a tailored Section 38 inquiry. Fifthly, that there's a reasonable prospect that would yield a benefit, not just in respect of accountability, but a material benefit in a very substantial amount of money to those people who most need it. And then finally, I want to make a point which I make with great care, because I am not accusing anyone of corruption in this case, but I do want to say that as a country, we have learned that a lack of accountability lies at the heart of corruption. And we respectfully submit that it is with the greatest respect, that it is vital to the constitutional project that the prospect of accountability should not be lost in this case. There is a real prospect of accountability, and we respectfully submit that it should be firmly grasped. Thank you, ACT Chair.
Thank you, Mr. Butler. And colleagues?
EDCJ, Mr. Butler, what you have in mind with this Section 38 inquiry, as I understand it, is a fully blown inquiry, and not merely to the limited scope of ascertaining what documents are needed and what documents should be delivered. You have in mind a proper determination of whether there has been proper profit shifting, on which the commissioner will then, the referee will then report to the court. Is that what you have in mind?
Yes, Justice Majid, as contemplated previously by the court in its Section 38 directions which were withdrawn.
What are your objections to the more limited Section 38 inquiry in ascertaining which documents are truly outstanding and must be delivered? Would you say it wouldn't serve the purpose?
Well, it would be a first step in the process, Justice Majid, but then somebody would then have to examine all of those documents and form a view as to what they mean and what their significance is, and you'd have to question people about it. You'd have to say to LASACA, why did you charge this amount for this? Why did CPS pay 437 million rand for the BEE expenses, whatever they are? Why this and why that? So producing the documents is only the first step. Then one has to examine what the documents reveal and see what conclusion one draws from them. And I don't think there is any material benefit in splitting that process into two. That will just lead to further delay.
The other option then of granting Treasury these coercive powers to do the investigations themselves, you say they are not suited for that, and they would have to get more substantial assistance, I suppose, to achieve that.
Well, Justice Majid, that's my projection and my understanding. I appreciate there's no evidence on it, on this before the court. But from what we know of what is said in the Constitution about the functions of National Treasury and what's said in the PFMA, the functions of National Treasury, this really falls pretty well outside what they usually do. And I assume they don't have staff available to do it.
Now, you will have seen in the liquidators report, the most recent report, the liquidator at paragraph 19 onwards make all kinds of allegations against Mr. Pierce. It says, at the inquiry, Mr. Pierce was represented by counsel. He was not re-examined by his counsel, which would have been done if he needed further information and so on. And he didn't approach the commissioner with a request to participate in the inquiry. Now, it's a disturbing feature of this case that the one party blames the other. Now, I'm not going to apportion blame, but what do you say about that allegation from the liquidator that Mr. Pierce did not raise any problems with regard to lack of information and so on?
Well, I wasn't present at the didn't participate in the inquiry, so I can only speak of what I know from what's on the affidavits. What Mr. Pierce says, he wasn't told, nor is he entitled to know who the other witnesses were. He wasn't entitled to attend the evidence given by the other witnesses or to cross-examine them. When he appeared, he wasn't told, no one took a statement from him for evidence in chief. He just walked into the witness box and he was asked questions. Fine. But it would have been, and most fundamentally, there were no questions raised about those Section 38 terms of reference matters, the allegations of shifting of profit. So what was Mr. Pierce to do? He answered the questions that were asked to him. He answered them he didn't satisfy the liquidator the liquidator argued with force that he'd lost his independence, but actually that's irrelevant. It's got nothing to do with the question of what the profits of CPS were. Ultimately whether Mr. Pierce's reports are good, bad, or indifferent doesn't determine the question of what the profits were. The profits arise from the facts, and those facts have never been properly investigated. So I know that there's a criticism of Mr. Pierce. Mr. Pierce was cross-examined he was cross-examined about extraordinary things. He was cross-examined about why he appointed me as his counsel. What that had to do with anything, I have no idea. He was cross-examined by counsel on why he appointed me as his counsel, and it was suggested that he had some sinister intent in that, which was very interesting to me. But all of this really has nothing to do, and the inquiry had nothing to do with what were the true profits, because those questions which Mr. Pierce raised in his report were not addressed with him. It is true. I need to say that Ms. van Straten gave evidence, for example, that it was impossible to untangle the expenses of CPS and the SASA. That's relevant to that question. That's a most extraordinary piece of evidence. But there was no focused inquiry directed at the questions which Mr. Pierce had raised with regard to whether there was a shifting of profits.
Thank you, Mr. Butler. Thank you, ADCJ.
Thank you, my brother.
DCJ?
Yes.
Mr. Butland, Mr. Pierce said that he hadn't, in fact, been furnished with the record of the 417 inquiry. Does he have it now?
Yes, he does have it now, Justice Rogers. After the event, he was finished with it. Yeah.
So when you say that the 417 inquiry didn't go into matters of profit shifting, and are you speaking only about the matters he was asked about, or are you saying that with reference to the entirety of the 417 record?
I haven't studied the entirety of the record, so I can't make any statement about that, except to say that clearly there was some question about how the costs were attributed as between CPS and LASACA. But I haven't read the other evidence, and I make no submission on that.
Because I think we need to be concerned if there's going to be a further Section 38 process, that it doesn't effectively become another Section 417 inquiry.
Yes.
The function under our current orders is not to determine whether CPS as liquidator can now recover monies from LASACA or anyone else. The function is to determine the profit. I appreciate that there may be a connection that if a certain expense is determined by National Treasury to have been inflated or improper, that it may disregard it in the determination of the profit. But it's not National Treasury's function, and it shouldn't be the function of any Section 38 inquiry that we authorize to determine whether, in fact, a claim lies to recover that money from LASACA. It does seem to me important that one should know what has been investigated. Earlier on in your submissions, you said, I talk about what was investigated at the inquiry. You said that according to the liquidator, National Treasury has been supplied with everything that she, the liquidator, got during the 417 inquiry. I don't know if that means that National Treasury has a transcript of all the evidence as well, but I'm not sure. I didn't ask Mr. Manetchi this. He can come back, take an instruction on this. I don't know whether, or we don't know, whether National Treasury, in its current attitude of saying that there's information outstanding, has studied the 417 evidence to ascertain whether some of the information at least might not be in the 417 evidence. I presume you can't say whether National Treasury has in fact looked at the record or not.
No, all I can say is that according to the evidence, I can say only two things, that it appears from the evidence of the liquidators that they gave National Treasury everything that they had arising from the inquiry, either transcripts or recordings or whatever, and documents. And secondly, what I can say is that National Treasury says we asked further questions, we were given information, but it didn't answer the questions that we asked. But
are you saying they asked in time? Is that after they received everything in the 417 inquiry, or is that an independent statement that National Treasury makes?
I'd have to go, it's at page 599 of the record. You need to make sure that I don't, that I get it right. It's page 599, paragraph 13.
Yes.
And what they say there, this is on the 15th of August 24, if I read it correctly. It's overprinted, the number, but I think it's 15 August 24. If I can just check that. Yes, the paragraph 13, what they say is, while some information has been provided by CPS as liquidators, the vast majority of the other information requested by the National Treasury has not been provided. Consequently, the National Treasury is in the same position and cannot proceed to make any determination. I was relying on that.
Mr. Manetchi will be listening, so when he comes back on the other question that my brother Majid had for him, he could let us know whether National Treasury has yet assessed the evidence in the 417 inquiry. I must just say as a comment, because Counsel for the Liquidator will be addressing us in due course, that I would be astonished if the question of profit shifting wasn't the subject of questioning in the 417 inquiry. It's not a matter one would have expected LASACA, who was represented there, to wish necessarily to pursue, but I would expect an independent liquidator to wish to pursue it, and SASA, as the major proved creditor, I would expect would wish to pursue it. So if questions of the royalties and the BEE payments and the like weren't investigated, it would appear to indicate a serious deficiency in the conduct of the liquidation investigation.
Yes, I can't say anything about that. All I can say is that Mr. Pierce was not asked about any of the. Mr. Pierce had raised those matters. He'd said there seems to be a problem here, and he was not questioned about it.
Well, I can perhaps understand that, because Mr. Pierce, by definition, couldn't give the answer to the questions. He had concerns, but he couldn't give the answer. One would expect people then to investigate with other witnesses what the answers to those concerns were. But But as I say, we can perhaps hear about that from counsel that are to follow.
But if I may just interject, Justice Rogers, one would also expect that given that he was an auditor who was appointed to conduct its investigation and make a report, that if his conclusions, his findings or questions were fully answered by evidence available to the commissioner, one would expect it would have been put to him and said, well, isn't this the answer? Here's what actually happened. You didn't know this and you didn't know that. None of that was put to him.
Thank you, DCJ.
Thank you, my brother. Any other colleagues? Colleagues, or rather, everybody present. Let us take the lunch adjournment and resume at 13:40. Ms. George?
Court will adjourn until 13:40. You are welcome to switch off your video or audio during the adjournment. Please switch on your video and audio upon return. If you exit the hearing, please use the same link.
Thank you. Ms. George.
Justices of the Constitutional Court, all counsel are back online.
Thank you. Mr. Butlander,
Yeah.
I did not thank you like I did everybody else before you. Thank you for your submissions.
Thank you, OCDJ. May I take the opportunity to correct some incorrect information I gave in response to the questions from Justice Rogers. Mr. Justice Rogers asked me about what information Mr. Pierce had with regard to the evidence which was given at the commission and so on. And I've received, my attorney has instructed me as follows. She says, we knew about our opportunity to make submissions. Judge Joffe said submissions must be made by the parties simultaneously, and so we inquired about what that date would be, and that was the information we were not given. She says Mr. Pearson Rain never received a record of the whole inquiry comprising transcripts of the other witnesses. There was a bundle of documents which we were provided with, which was called the record for the purposes of providing written submissions. It was all of the documents that were before Mr. Pierce at the inquiry, his report, annexes, correspondence, etc. I said, asked not the transcripts or audio copies of the evidence of other witnesses, and the answer is no. So Mr. Pierce has not heard the other witnesses, never heard the other witnesses, was never given their evidence. But in fact, he made an application in this regard. And I'll provide copies of the letters to the court and to the parties. But on the 23rd of September, the attorneys wrote to Judge Joffe and said, our client understands that previous witnesses before the inquiry have testified in regard to the contents of a verification report prepared by our client and submitted to the Constitutional Court, dealing with the audit verification exercise undertaken by Rain Chartered Accountants, Inc. Our client has asked us to inquire from you as to whether you would release to him a transcript of this testimony under such conditions as you deem fit to impose to assist him in preparing his evidence to the inquiry. And then the retired commissioner issued a ruling, and he said the following. He said, Pierce's attendance before the inquiry is required in respect of 2 audit verification reports prepared by Rain Chartered Accountants. Pierce was apparently the draftsman of the reports. The reports were prepared by Pierce pursuant to an order of the Constitutional Court. Witnesses who have already testified at the inquiry have testified in regard to the additional report. In a letter dated 23 September 2022, addressed to me by Harris Newcomb Molobatsi on behalf of Pierce, I am requested to release the transcript of the evidence, I assume relating to Pierce and the report, to assist Pierce in preparing his evidence at the inquiry. VFV attorneys acting on behalf of the liquidators oppose the release of the transcript. Their submissions are contained in a letter directed to me dated 26 September 2022. In the letter of VFV attorneys, reference is made to the judgment in Leach and others versus Faber and others, 2000 Part 2 SA 444 WLD. It appears from the judgment that an inquiry must be conducted fairly. What falls to be determined is whether not giving access to the relevant transcript of the evidence would result in the inquiry not being conducted fairly. Pierce will no doubt be questioned in regard to his reports, including their preparation and his dealings with others in regard thereto. He has personal knowledge of the issues that will be canvassed with him. In the circumstances, there is no need for him to be precognized of the evidence already led at the inquiry. The request made on behalf of Pierce is declined. And so the result is that Mr. Pierce didn't know when he gave his evidence, and he still doesn't know to this day what evidence, if any, was given by others with regard to his reports. And he wasn't questioned in that regard. Thank you, Judge.
Thank you, Mr. Butlander. Any questions, colleagues, on this information? Thank you, Mr. Butlander.
Thank you.
Mr. Smith.
Thank you, Acting Deputy Chief Justice and other justices. May I commence with the last submission by my learned friend, Mr. Butlander? Reference is made to correspondence in September 2022 when the inquiry was still ongoing, but the complete inquiry record with documents were provided to his attorneys on the 18th of October and the 26th of October 2023. In an email directed to, I don't know how you pronounce her name, Mira Brill, and copied to Charles Newpen, a WeTransfer link was sent at 12:14 on 18 October 2023, and again on 26 October 2023 at 2:01 p.m., to which there was a response from Mira Brill. Dear Ms. Kawala, we confirm receipt of the link and confirm that we can access it. So since October 2023, Mr. Pierce has been in possession. The correspondence to which reference is made was a year before, and certainly the entire inquiry record was complied with, was provided. And it wasn't only provided to Mr. Pierce, it was provided to all the witnesses, the entire record with the documents obtained at the inquiry. It is perhaps prudent that we go back to what this application, how this application came about and what was sought from the liquidator. In the notice of motion, it was sought that the sixth respondent, Cash Paymaster, provide all the information to National Treasury. In each instance, all the information had to be provided to National Treasury in order for National Treasury to comply with a court order. What then happened is affidavits were filed, and the suggestion is made by both Full and by Rain that there was non-compliance, or the innuendo at least, is that there's non-compliance by the liquidator as far as the documentation is sought, as far as that is concerned. Now, in the first heads of argument, the main heads of argument filed by Full, they said at paragraph 41, if the information is in fact not found in either party's possession, that's a reference to CPS and LASACA, despite a diligent search, it cannot be provided by them, and then CPS and or LASACA would simply need to advise the National Treasury of this and indicate in whose possession the information may be if this is known. As I've indicated, 3 affidavits were filed by the liquidator explaining chapter and verse what was collected, what was collected through the inquiry process, and that it was provided to National Treasury. Those 3 affidavits are dated 4 May 2023 at page 249 and further, 3 November 2023 and 21 August 2024. The latest, to which no reference is made by either Full or by Rain, or by Treasury for that matter, they refer simply to the affidavit of Ms. Maria and of Mr. Khan. But in the affidavit of the liquidator of 21 August 2024, which is at record page 615 and further, it was explained by the liquidator that the record was provided to National Treasury on 18 and 26 October 2023, so the same dates that we've heard about those emails now, and on 14 November 2023. And all documentation and evidence received at the extensive inquiry was provided to National Treasury. And then the liquidator goes on to explain, the inquiry enabled me to investigate the affairs of CPS, including potential claims against it, for instance, the Commissioner of the South African Revenue Services, and potential claims that it may have. In addition, it enabled me to obtain clarity, information, and documentation to assist National Treasury in their task of determining the expenses incurred income received and net profit earned by CPS under the contract. The liquidator then goes on to explain in paragraph 7 at page 618 and further that on more than 10 occasions correspondence was directed to National Treasury in which cooperation was tendered, in which the liquidator, as she states in paragraph 6 at page 617, states, I would avail myself to discuss the evidence and documents insofar as I may be of assistance. A meeting was then arranged and took place on 11 April 2024, where Ms. Maria of National Treasury was present with a legal representative, an in-house legal representative, and with the legal team and the liquidator. At the meeting, the issues raised by Mr. Pearce in the first and second RAIN reports were discussed at length, with reference to the evidence, the information and documents received and obtained through the inquiry. That is paragraph 8 of the affidavit at record page 618. Thereafter, further correspondence again followed, where the liquidator directed through the attorneys some 5 further letters or 6 further letters. That's paragraph 9 at page 618. And it was recorded that National Treasury is to contact the attorneys if any other assistance in understanding the inquiry record is required. The record is voluminous and cross-referencing to the documents referred to could be difficult. Then this application was set down for hearing on 7 May 2024. And at the meeting that was attended by Ms. Karen Marie and Esther Pari on behalf of Treasury, the liquidator was informed that something would be filed prior to the hearing of 7 May 2024. We know that the one affidavit was then filed in which reference is made to Ms. Maria, and Ms. Maria confirmed that it was based on Mr. Pearce's report. So that was then followed up again on 9 July. Treasury directed correspondence to the attorneys of the liquidator. The letter did not take any issue with any particular aspect raised or recorded in the letter of VAV. That is the letter that the attorneys directed on 22 April 2024, in which the events at the meeting of 11 April 2024 was recorded. It's a comprehensive letter. But again, National Treasury did not take issue with any particular aspect. They, in the vaguest of terms, said that Treasury does not necessarily agree with the personal views and opinions. VAV, the attorneys for the liquidator, again followed up, and there was no response received. So from paragraph 14 and onwards, it is then explained at record page 619 and further that Treasury was informed throughout that the liquidator would cooperate, and that there's been no request for assistance from National Treasury. It was recorded that the liquidator fully cooperated with National Treasury throughout the process and have made every possible effort to provide the information. So what then happened is that National Treasury did not approve the RAIN reports, and what the court will find at paragraph 17, page 620 of the record, is that National Treasury did not approve the RAIN reports. This was conveyed by Karen Maria inter alia during the inquiry and at the meeting on 11 April 2024. It is difficult to see how National Treasury would in these circumstances use the updated report of RAIN as a starting point of reference. In paragraph 18, it is said, Mr. Khan asserts in paragraph 11 that it is undesirable to disregard the extent of work that has been done by RAIN. This is the first time that National Treasury has said this. And then importantly, still paragraph 18, fourth line at 620, Karen Maria testified at the inquiry that the only way in which the profits earned by CPS could be determined by National Treasury was to appoint a further independent auditor to conduct the entire calculation afresh. And then the liquidator said, I'm not expressing my views thereon. I am simply recording what the evidence was in this regard. And that is inconsistent with what is now stated by Mr. Khan, that is in his affidavit. In paragraph 20, Mr. Khan, reference was made to paragraph 13 of Mr. Khan's affidavit, where he said that the vast majority of the other information requested had not been provided, and that National Treasury is in the same position and cannot proceed to make any determination. But as the liquidator explained in paragraph 21, I find this contention remarkable and unacceptable, considering what was provided in October and November 2023 and the multitude of letters that were written to National Treasury and the meeting. And the court will note, still, Treasury has not recorded in any correspondence in response that they had any difficulty with the record or with the information. They do so by way of affidavit, which the liquidator has demonstrated is inconsistent with the correspondence which were directed. So when we have regard to this affidavit in its entirety, for instance, National Treasury was advised that there were 2 laptops with the working documents of KPMG and Mazars. This is paragraph 24.2 at page 623. They could call for the laptops, but they did not. And the liquidator goes on to indicate that Ms. van Straten testified. She was the chartered accountant appointed by both Cash Paymaster Services and by Net1 Lesaka. She attended to the financial statements of both. She gave evidence at the inquiry that it would be impossible for the liquidator to respond to the paragraphs or to the aspects raised by Mr. Pierce in his report. And that was mainly due to the interwoven nature of the various businesses and because no separate accounting was done between Net1 and CPS in respect of the SASA contract. The court would have seen from the heads of argument that much was made about the interwoven nature and that it is not possible. But what the evidence of Ms. van Straten is that you could not effectively take a line item and carve out on that specific expense what is to be attributed to the particular contract. Cash Paymaster Services had more than one contract. If, for instance, software had to be obtained or secured, then a portion of that would have been for the SASA contract. But her evidence was, and she was the person best positioned, that it would not be able to determine it. But that is why the stance taken by the liquidator, as it would appear at paragraph 28 of the affidavit at page 625 of the record, is the following. She says, surely if no evidence can be provided in support of a particular expense, National Treasury will consider whether in its opinion the expense should be disallowed and whether it should increase the profit made by CPS under the contract as determined by National Treasury. The outcome of the calculation does not affect the winding up process of CPS. And that is also consistent with the letter of 22 April, paragraph 10 thereof, where the liquidator made it clear at the meeting that, or suggested to National Treasury that it should take the information that could be gathered and take a robust approach, basically ignoring or disregarding an expense if there was no supporting evidence for it, which means that the profit would be increased. But it has no impact ultimately on the winding up, in the sense that there are limited amounts of money that have been recovered, and the claim of SASA alone amounts to some 700 million rand. Now, that claim on its own originates from the judgment of His Lordship Mr. Justice Tsoka, which was confirmed in the SCA, in terms of which the bulk re-registration fees were ordered to be repaid. That amount, the claim amount of some 700 million rand, consists of the amount that was paid plus interest thereon. So we submit that where we are today, the suggestion that the liquidator, and it's not identified by either rain or by full who it is that they say did not cooperate. But our submission is that the liquidator has fully cooperated to the extent that she could. She has explained it in her affidavits. She filed 3 affidavits, and if we are to take full at their word, then what they submit in paragraph 41 of the heads of 3 November 2023, it would be acceptable if there is an affidavit or that we simply need to advise National Treasury to the effect. I heard my learned friend, Mr. Cousteris, speak about an affidavit, a further affidavit being prepared for National Treasury by the liquidator, but we don't see how that would arise in the circumstances where the liquidator has already filed 3 affidavits in this very matter. The next issue, well, perhaps I should just clarify this aspect. We were a bit surprised when our learned friends for full made the submissions after the filing of the affidavits at paragraph 20 and 21 of the submissions of 9 May 2025, that the factual point of departure is that there is no dispute that the implementation of Treasury determination order and the public accountability it was meant to vouchsafe has stalled. National Treasury says further information is required to determine CPS's profits, but that information has not been forthcoming. National Treasury's latest submission confirmed this position, but there's no reference that they make to the affidavits of the liquidator. It appears that they've ignored it. Then the next aspect that I need to deal with is the aspect of the inquiry. It is correct that the inquiry convened. My learned friend, Mr. Butlander, submitted to this court that the issues raised in the first and second rain reports were not canvassed with Mr. Pierce or at the inquiry. That's the way I understood his evidence. That is not correct. And they've had the record from October 2023, and he would have been able to identify those parts of the record to demonstrate to the court and to inform us what it is that he suggests was asked or wasn't asked from witnesses. In fact, what we did is we took the rain reports. The first rain report was the only one available when the other auditors testified. I'm talking in particular about Deloitte, who were the external auditors of Cash Paymaster, and of KPMG and of Mazars. The issues raised in the first rain report were dealt with in detail with those witnesses. In each instance, they were given the opportunity to respond thereto, to say what is their response to Mr. Pierce's view on a particular item. And in most instances, their response was to the effect, against which standard did he measure it? So what standards did he apply when he prepared his report? Because they did an audit and he did a different a fact-finding report, and I think IRSR or ISRS 4400, which is an agreed upon procedure between a client, in this instance SASA, and RAIN, Mr. Pierce in this instance. But so the second report was provided in June 2022. It wasn't provided to us to utilize. It was only raised or provided under the National Treasury affidavit. On the same day that they filed, in the Constitutional Court, they said, we realized that we didn't provide it to the liquidator to respond thereto. Nevertheless, the second report and what was dealt with therein was taken and utilized in the inquiry, and witnesses were again asked about the contents thereof. And in particular, I referred to the evidence of Ms. van Straten, the chartered accountant employed by the 2 companies. Each of the items in both the reports were raised with her in detail, and she gave evidence about it. So the report of Judge Joffe has not been provided. The reason for that is twofold. First of all, there is a huge cost implication for it. And you would have seen from the report of the liquidator that we are litigating against SASA in respect of the costs of the inquiry, including the cost of the commissioner. The second is because of the National Treasury function and this court ultimately having ordered Treasury to determine the profit. The report of Justice Jaffe will not come to a determination on what the profit is, or will not make a finding in respect of each line item. He will summarize what the evidence was, and we submit that the provision of the inquiry record to all involved was overtaken or overtook the purpose of that report to a large extent. The next issue then is what our learned friend for full contended could happen after such investigation. Today he limits it to a Section 38. We did file our submissions and say that we agree with a Section 38 process in accordance with what the court originally ordered. But mention was made of aspects of piercing the corporate veil, collusive dealings, Section 31 of the Insanity Act, and so on. Those were not canvassed in any of the papers before this court, but it may be that upon conclusion of a Section 38 process, that one may find information to that extent. At this point in time, the point is no piercing of the corporate veil has been identified. We know that Section 20 sub 9 is available in terms of the Companies Act, but there's no evidence at this point in time that that would find application. Collusive dealings in terms of Section 31, we have not found that to arise. And an important factor to be considered is that most of what Mr. Pierce complains about happened in the first 5 years, from 2012 until 2017. So the majority of the items complained about happened 5 years. Well, not even 5. We're talking about from 2012, in the 5-year period up to 2017, KPMG gave the report as far as that is concerned, and then for the 18-month period thereafter, it was Mazars who gave the report. Mazars did not raise any issue. Deloitte did not raise any issue as far as the external auditors, as far as irregularities are concerned or potential claims against anyone else. There is existing litigation, as we indicated, against SASA in respect of the determination of the increased fee for the 18 months after the expiry in 2017. That is pending, but that is part of the litigation, and then the litigation with SASA, and we have identified in the report the other potential claims that that appear from the C100, although those are small amounts, but we have a hefty amount of 52 million rand in respect of Cash Paymaster Services Northern Pty Limited, which is also in liquidation, but it appears to us that litigation is unavoidable. There are pending actions or pending review proceedings in respect of the SARS assessments, and we submit that nothing, the uncontroversial assets have been set out in paragraph 7 of the report, consisting of some movable assets, some monies received from Nedbank, and then the vast majority from the sale of vehicles by the business rescue practitioner. So this company was in business rescue for a period of time before the winding up. The winding up only took place in 2020. So we submit that there's nothing before the court as far as the piercing of the corporate veil is concerned, but it may be that something will be unearthed in the proceedings. There will not be duplication between the two proceedings, because the aim of the Section 38 will be to determine the profits. So effectively, it will be doing what National Treasury was obliged to do. It will take all the information that can be gathered, and then I presume that the Section 38 inquiry, I know that there's potential of a limited inquiry just for the information purposes and then providing it to National Treasury. The problem is, as indicated by Ms. Maria on National Treasury side, is that National Treasury would have to appoint a third party or a further independent auditor to conduct that investigation. So that is problematic. Then as far as the Section 38 is concerned, SASA and Treasury have indicated that the cost should not be an issue. We agree that there should be a limitation on the time. SASA is the major creditor in this estate. Effectively, what is happening is that the winding up is being extended at the cost of SASA. SASA participated in the inquiry proceedings. They did not raise any issues. They asked questions of witnesses. They directed questions to witnesses. But ultimately, it's SASA who must be paid what can be paid by virtue of the winding up process. But we submit that a Section 38 is more, would be the better approach in the circumstances. National Treasury, with the powers or additional powers, would not be of assistance, we submit. So in our submission, a Section 38, basically according to the order previously granted by this court, should follow. Thank you, Justice.
You're muted, Justice Matlanga.
Thank you, Mr. Smith. Colleagues?
May I, ADCJ, Mr. Smith, if a Section 38 referee should approach the liquidator and say that they must furnish documents under their custody and control, under the liquidator's custody and control relating to CPS, the stock response, I suppose, would be that they have furnished everything they have nothing further. Am I correct?
Correct. That is correct. But to the extent that she can assist with the inquiry record, for instance, to find cross-referencing, that assistance will be provided. We have thousands of documents, pages of documents, and the cross-referencing may be problematic, but the liquidator will give her assistance to the referee.
Now, when the liquidator says that she has there's no prospect of getting further funds from third parties, that's based on what is available at the moment. It doesn't deal with the question of possible voidable dispositions, the question of profit shifting and so on. You accept that?
It deals with the voidable disposition. It doesn't deal with the aspect of profit or expense shifting, as you've indicated. Yes, Justice.
How does it deal with voidable dispositions? Can you explain that?
Well, we've looked at transactions, payments made in the 6 months and 2 years prior to winding up, and whether they are voidable dispositions in terms of Section 26 or perhaps Section 29 of the Insolvency Act, whether there's been a preference to a creditor and whether they were dispositions without value. We could not identify such payments or potential voidable dispositions. Again, bearing in mind that we are dealing with a liquidator who was appointed in 2020 and that these issues were in the 5-year period prior to that. So many of the aspects are fairly old. It's historic, but we did look at the transactions to see whether there are voidable dispositions and preferences in terms of Section 26 and 29.
As I understand your argument, you saying that a limited Section 38 referee process would not be of much help, because as Treasury says, there'll have to be another auditor independently appointed to then look at all those and make a determination.
That is our submission, and that is the problem that Treasury has faced and conveyed to us at the inquiry and thereafter.
And again, I suppose the same answer if one would explore granting Treasury-wide coercive powers to do the investigation itself. I suppose the same answer?
The same answer, unfortunately.
Yes. Thank you. Thank you, ADCJ.
Thank you, my brother.
Deputy Chief Justice. Mr. Smith, may I just ask, were you counsel for the liquidator at the 417 inquiry?
I was.
In the context of the points raised in the RAIN reports, particularly the evidence that was taken from witnesses from KPMG and Mazars and the audit they had done, was the upshot, I'm sorry, I'm to some extent going outside obviously what's on the affidavits, but the record's available to everyone apparently, not to us yet. But was the upshot of that evidence merely that KPMG and Mazars had vouched, could trace and verify major items of expenditure, or did it go into the question whether it was justified? You've heard what was said about by FUL's counsel on how royalties shot up shortly after the All Pay 2. Were the questions of the quantum of royalties, for example, and whether they were justified by some agreement or on some other legal basis, was that the subject of inquiry?
It was the subject of inquiry following on the report. The response from these auditors invariably was to the effect, what standards did Mr. Pierce apply to get to his conclusion? So they clearly did not conduct a magnifying glass investigation on each of those royalty payments. They, for instance, this is my recollection, Justice Rogers, they did not pick up the spike in the payment of the royalty fees in, I think it was 2012 or 2013, thereabouts, that my learned friend for freedom under law referred to. But they certainly dealt with it. It was raised with them that this is what Mr. Pierce had to say in his report about these issues, and they responded thereto.
In regard to resurrecting a Section 38 inquiry, there seems to be a bit of a gap in jumping from where we are now to a Section 38 inquiry, and that is that although the liquidator has provided the entire transcript and all the documents to National Treasury, to RAIN, and everyone else, SASA, it appears that National Treasury may not yet have looked at any of that, and they apparently have not taken up the offer of the KPMG and Mazars laptops, which have got their working papers, which I think deal inter alia with royalties and registration fee payments and the like.
Correct.
I would think that at the moment, a Section 38 inquiry on those matters, at least insofar as your client is concerned, and at least insofar as all the witnesses who testified at your 417 inquiry are concerned, your inquiry already covers the ground, but National Treasury hasn't looked at any of it.
Correct. That's certainly
so
the way.
So it appears to me we can't yet be sure to what extent a Section 38 investigation is needed, because we may end up duplicating a process that at least substantially has already been covered by the 417 inquiry. Just roughly speaking, over how many days, I know it would have been spread out, roughly how many days did the inquiry sit for? Are we talking about 10 days, 30 days?
No, it was 16 days.
16.
16.
16 days. In the course of that inquiry, and particularly in regard to Mr. Pierce's concerns, were any witnesses from LASACA subpoenaed and questioned?
Yes, there were. A number of witnesses.
So
I'm sorry, yes, Justice.
Sorry, and they, were they questioned on inter alia on concerns that he had?
Yes, but let me just clarify this aspect. So there's Mr. Pillay, Mr. Smith. They, in the main, deferred to Ms. van Straten, being the financial manager or the financial director, the chartered accountant employed by the two entities. And it was Ms. van Straten who gave us the best evidence as far as the information is concerned. So Mr. Pillay, for instance, testified about what the BE, the expenses, what it was for, and how they required cooperation from people in the villages where these vehicles of Cash Paymaster would go to give cash, to give the grants to, or to pay the grants to recipients. So that's the type of information that they would be able to give. But as far as the detail is concerned, they deferred to Ms. van Straten.
But she was also questioned on these matters. So unless she is better questioned or remembers stuff that she didn't remember previously, her evidence is on record.
Her evidence is on record, yes.
I know it's difficult to say, and I don't sort of hold you to an answer that you give, but I'm concerned that the people who could shed light on the matters of concern to Mr. Pierce have already been questioned. And we can't be confident that in a further investigation, they will come up with anything more.
That's quite possible, but don't hold me to it, Justice. But I think that is going to be the answer. The answer will probably be from Ms. van Straten. You are going down a rabbit hole where you're not going to get the definitive answer on the profits made in terms of this contract for the very reasons that she advanced at the inquiry.
Three of the big ticket items have been mentioned by, I think, Mr. Koutsides in his address. The one are retrenchment costs, which apparently weren't paid, although it was, as it were, budgeted for. Is it clear that those expenses weren't paid?
They weren't paid, and they were included, if memory serves me correct, in the 2017 or 2018 year. They were included, so it was at a time when the contract was nearing its end. So it was included, but it was not ultimately paid. We established that at the inquiry, and this we conveyed to National Treasury to say, well, it wasn't paid. That part of the profit has to be increased.
So if that's part of the 253 million that's currently been certified, it was taken into account as an expense by Mazars, but perhaps it should be reversed.
Correct.
The BEE expense, is it also so that was that paid or wasn't it paid?
I can't speak. I'm informed by my one attorney that it was paid, but I can't recall expressly or I can't recall exactly whether it was paid. What I do recall is that there was evidence as far as the contracts are concerned. Some of them were not implemented, but I can't give you more detail at this point.
And then you said in regard to the royalties, what might be thought to be a suspicious spike wasn't at least covered by the accounting witnesses. Was it covered by anybody else?
Not the specific spike. Not the specific spike, but the ticket item was discussed. And the response from
just in the light of what you
sorry. No, that's what Van Straten testified about the ticket item, and that because there are more than one, because you have more than one contract for which it was utilized, it would not be possible to carve out that particular amount attributable to this contract, to the CPS SASA contract.
I assume if the auditors confirmed the expense, then leaving aside precisely in which month it was paid, they satisfied themselves that the total royalties paid were backed up by agreements.
Yes, it must be, otherwise they wouldn't have signed.
So then, coming back to it, what is the position? Should we be? You say your client doesn't oppose. In fact, I think you supported a continuation of a Section 38 process. But is it something that should proceed at this stage without National Treasury and perhaps SASA as the major creditor examining information, a lot of information, which apparently they haven't looked at?
Yes. Justice Rogers, what the liquidator wishes to finalize the winding up of this company, or to progress it at least. This has been ongoing for a long period of time, and we've considered what the best option is at the moment. And because of the evidence given by National Treasury, where they said that they will have to appoint a third party, and the fact that they haven't cooperated or responded to our correspondence and clearly haven't read the record, we have difficulty to see how any process where they are involved will result in a finding as far as the profit earned under the contract is concerned. So that's towards Section 38.
It may be that National Treasury ultimately doesn't have the capacity to determine the profit, but that's what this court said. It said we've got RAIN to do its verification exercise and report to National Treasury, which makes the final decision. Are we now saying that the process that this court set up isn't adequate to actually determine the profits?
Well, it's proved to be ineffective because National Treasury has not done what they were supposed to do. They could have furthered the process. They did not come back to the liquidator in one piece of correspondence to say, in addition to what we have provided, we also require the further, or come and help us, or provide the 2 laptops, for instance. I would have thought that that would be the starting point for any chartered accountant or auditor that's appointed by National Treasury to investigate these aspects. Those 2 laptops.
My concern about what has now become called the wide Section 38 inquiry, which culminates in a referee actually determining the profit, is that the referee then has to report to us, to the court.
Yes.
And this court then has to make a finding on the profit. And we will have to hear everybody, and arguments that were perhaps made to the referee and rejected will be made to us, and we'll become the determinators of the profit.
I understand this.
But I can envisage that we would be happy to, on the report of a referee, to determine whether all the information and documents are now to hand. But the advantage of the process that this court originally set up is that ultimately National Treasury makes a determination. And if somebody wants to take that on review to say that the determination is wrong, then I think they would have to start in the High Court to review it. The 38 process just lands us up in effectively another long hearing about profit. It may or may not, but we just can't know. Everything in this case seems to have been contested and controversial. So I can't see why the determination of the profit pursuant to the referee's report wouldn't similarly be before this court in a year's time.
But the same goes for National Treasury. Even if they attended to it, at the moment we just don't see proactive steps being taken by Treasury.
No, I understand that, but at least that National Treasury would be determining the profit, as this court previously said, not the court. The court wouldn't be determining it. And if somebody said that National Treasury hadn't brought the judgment of a reasonable person to bear on the certification exercise, hopefully at least that could be something that could be litigated in the High Court. I'm not saying it would be quicker, but this court is not well suited to the function of adjudicating the amount of profits based on a referee's report.
I understand
that. That's my concern.
Yes, and it's well made, the point, Justice Rogers. It is a concern that should be considered in weighing up. It seems to me that there's no clear answer or clear path that will result in an answer that the accountability actually requires.
Thank you. Thank you, DC Chair.
Thank you, my brother. Any other colleague? Thank you, Mr. Smith.
Thank you.
Mr. Blow.
Thank you, Deputy Chief Justice. Good afternoon, everybody. Can you see me clearly? I think you can. Right. I've now, I think to some extent, had the benefit of hearing what all of the various parties have to say. I want to synthesize that and deal with it insofar as Lusaka is concerned. And I think it's very important that I clarify from Lusaka's perspective what it understands its role to be in this case. And in particular, what limitations there are, in other words, where it is not featuring, and then move on from that to whether it can be of any assistance on the issues that we believe are properly before the court, as opposed to issues that are not. Might I start just by recounting some common cause history? There's been a discussion about Lusaka and joinder, and what it is that certain general statements by Mr. Katsidis about Lusaka can't claim to have been unaware of proceedings. I'm not sure what that's meant to be or say. Other references in the heads of argument and some of the argument today by Mr. Budlander about Lusaka having been joined in these proceedings, interlocutory matters. Lusaka's position is very clear and has been very clearly set out with respect in our heads. Lusaka has never been party to any of what we call the all-pay litigation in any substantive sense. It has not been cited as a respondent in any of the all-pay judgments that give orders of substance, whether it be the setting aside of the contract, whether it be the order for the accounting, or for that matter, any of the...
Please pull your screen towards you.
I'm sorry. Let's see if I can get it a bit better. Does that make it? Sorry, yes, apologies. Nor for that matter for any of the sequelae relating to the manner in which the accounting relief was to be given effect to, insofar as CPS was concerned. Its only feature in any of these matters has been that it had been mentioned by Mr. Pierce in his two reports as possibly being the beneficiary of transactions that he says he suspected but couldn't establish, might have not been accounted for correctly in the books of CPS. So that's the starting point. Its first feature in this matter then was this present application for its original relief, which was brought on the 23rd of March, 2023. And that application, which is the one that you're dealing with now, sought relief in the alternative. Effectively, that's at page 2 of the papers. Said that Cash Paymaster must provide National Treasury with the information that it seeks in its affidavit of 10 September 2022. I'll get to those items in a moment. And to the extent the alternative is if the information is not in CPS's possession, but is in the possession of Lusaka, then CPS must obtain that from Lusaka within 40 days from the order, or if CPS is unable to obtain that information, CPS must write to Treasury within 20 days of the order, indicating the nature and extent of the information that is in possession of Lusaka and which CPS has been unable to obtain from Lusaka. And Lusaka must furnish National Treasury with the information specified in CPS letter within 20 days of receipt of CPS's letter. National Treasury, should it deem necessary, write to CPS or Lusaka requesting any further information that it requires in order to determine CPS's profit within 10 days. And should National Treasury request any further information from CPS Lusaka, that must be furnished within 20 days of receipt of the request. And then National Treasury must determine the profit made by CPS from its unlawful contract with the third respondent, SASA. that is the relief that was sought. That was preceded by some months, I need to get the exact date, by an application to which Lusaka was not a party for an order declaring that CPS must repay the profit that is ultimately determined it made from the contract by National Treasury. What then occurred was a direction from this court. All the parties filed submissions. At that stage, I'll indicate to you my personal involvement because there might be some questions about the conduct of the inquiry. At that stage, I was instructed on behalf of CPS and the parties filed heads, and CPS filed heads indicating in connection with the, let's call it the repayment relief, that it did not construe the order as obliging it to repay. That has yet to be determined, and this court then gave a directive that this application regarding the determination of the profit should proceed before the court considers the question of liability. In other words, whether the order, let's call it the original or all pay to, in fact entails a consequential payment obligation. That certain questions from the court today and from the way in which the Friday direction regarding CPS's ability to pay seem to me to assume that the question of liability to pay has been decided. I just, and I may be wrong, and I hope I'm not being presumptuous, but that the question of whether even CPS has an obligation to pay pursuant to all pay to has not yet been decided by this court. In fact, the SEA in another matter between other parties has interpreted that judgment as not requiring an obligation to repay, but simply an obligation to account. Now that is, it seems to me, of some moment with respect, because this court is obviously concerned, and rightly so, with the length of time that this matter has taken to reach some sort of resolution, even on the accounting question, and the uncertainties created by the RAIN reports and how they've been dealt with by the various parties. I just wanted to say that if the court is looking at practical considerations, which means recoverability ultimately and not just accountability, then the question of liability has to be determined before that can be considered. If the import of the RAIN judgment, so the all pay to judgment, is only that CPS must account for the profit that it made, in the sense, and I'll go through those orders very quickly, in the sense of the way in which an auditor would account, because this is an auditing function that's being performed. It is not an open-ended inquiry into profit. It's not a damages claim. It's not even a claim for a statement and abatement of accounting. It's an audit verification that is required to be performed by Treasury, which is to come to a number applying auditing standards. And so that number, I have some doubt as to whether the original framers of all pay to intended a number achieved by National Treasury, and as Judge Rogers has repeatedly pointed out, not decided by this court, should form the basis of a repayment order without any other proceedings. In other words, whether Judge Fruneman, in penning that judgment, which I read from Fool's Heads in this matter, was done without argument from any of the parties as to the formulation of that judgment, mero motu by the court. I think there's significant doubt as to whether, applying standard tests of interpretation, the court actually intended that there should be repayment. This is particularly so, notwithstanding Mr. Bunden's closing remark, that there was no finding of corruption in this matter, because that may change things ultimately. There was non-compliance, there was a material irregularity, it resulted in the setting aside, it resulted in the catastrophe and the remedial orders the court has granted, and it also resulted in the need for accountability. But there has not been a proper debate in front of this court, and there are two sides to that discussion as to whether CPS is liable to repay profit or whether it's liable simply as a matter of a sort of deemed organ of state, accountability-wise, to indicate or so that Treasury can say exactly what profit it made from an unlawful contract. So one should not, with respect, get ahead of oneself in these inquiries too far. And the concern that Lusaka has is this. And I must say the concern arises from the manner in which the litigation has been conducted. I'm not pointing fingers, but I listened to certain things today with some consternation as far as Lusaka is concerned. What this court is definitely not concerned with is whether even if CPS has a liability or an obligation to repay the profit determined under All Paid 2, however it's determined. What is certainly not under discussion today is whether any liability would be attracted by LASACA by virtue of other causes of action that have never been hinted at, let alone ventilated in front of this court. So there are two or three possibilities that have been mentioned. One has been voidable dispositions under the Insolvency Act. There only a liquidator can sue. Only the liquidator of CPS as locus standi to sue for avoidable disposition. And it can do so on the basis of some of the recognized grounds, all of which entail a disposition either collusively or at a certain time, not for value, or which had the effect of preferring creditors and was outside the ordinary course of business. No matters that this court should concern itself with in any realistic sense. The second type of action proceeding referred to by Mr. Koutsoudis and even by Mr. Smith is some kind of piercing of the corporate veil in terms of section 20(9) of the Companies Act. Now that, presumably, any creditor could bring. So SASA would have locus standi to bring that. Those are matters which, if they're ever going to arise, will arise in a trial at some point where LASACA would have to be cited as a proper party. Nothing, I just want to make LASACA's position entirely clear. Nothing that the court says or does in these proceedings, this court has not been asked to touch on LASACA's liability under any possible future cause of action that might arise from something said in the Rain report or elsewhere. This is made clear from the fact that, besides the fact that LASACA hasn't ever been cited in its capacity as a possibly liable party under the all-pay litigation, Mr. Budden went so far as to refer to other parties within the LASACA group who might have apparently benefited from some kind of undue payment. This is not even before the court. I don't even know who they are. So what this court is not concerned with is any procedure that has anything to say about whether LASACA, or even CPS for this matter, is liable for the repayment of the profit. But if, and CPS can fight its own battles, ultimately the court were to come to the conclusion that CPS was to repay the profit, then one gets to this practical question of its insolvency and its very, very serious its balance sheet that shows a very, very serious deficit. Now, on that, I could just make the following the following submissions. We absolutely understand that even in the context of accountability, Treasury should be put into a position to the best degree possible to make a determination. But it is an audit determination. Auditors do not determine profit. Auditors do not determine anything. Auditors give a report in the same way that Mazars and KPMG gave reports in terms of international auditing standards. And one doesn't have to be an expert. As Mr. Koutsoudis says, that nothing that we say can be taken seriously about the auditing disputes because we're not auditors. It's very simple. We cited in our affidavits what the auditing standards require. This court in All Pay 2 required an audit of the profit of CPS. And that is bedeviled by the following complications. Besides the fact that an audit is simply a statement that the financial position of what was earned under that contract as profit, the net profit, the audit test is, does it fairly represent the profit in all material respects? Not is it an absolute determination, whether for a liability to pay or otherwise. The complexity is twofold. Firstly, CPS had other businesses. And this is the complexity of interwoven, which Mr. Smith has spoken about. Secondly, the period of the contract doesn't coincide with CPS's financial year. And so you don't have a set of audited financial statements on which you can borrow. All you have is audited financial statements that cover the period, both of CPS and, for that matter, LASACA, which are tended to by a highly reputable firm of auditors being Deloitte. And no one has suggested that KPMG and Mazars are not reputable or that their findings can't be trusted from an integrity perspective. What you have is then, and it's been pushed to the sideline, but I think it's important. What you then have is Mr. Pierce producing a report that in its terms is not an audit and says doesn't purport to be an audit. because he makes no findings about the matters in respect of which he has suspicions, and where he suggests that KPMG and Mazars may be wrong, but that he can't give you or Treasury an indication of what he actually thinks. He says because all the information has not been to hand. And all that report tells you is that he thinks there are certain matters that should be investigated further. He doesn't even give, as we've pointed out in our heads, a qualified report to say, I'm prepared to accept everything is correct, but for these matters, which was his obligation anyway. There was no statement in all pay audit that the audit report had to be qualified or unqualified. It had to be an audit verification insofar as it was possible. The only point I make about that in respect of RAIN is that its reports, the items in its report that feature in Treasury's affidavit have been simply parroted by Treasury, and it's apparent without having considered them. And I'm sorry to have to say this, but Treasury, with respect, has not fulfilled its mandate here in two respects. Firstly, it hasn't considered, with respect, Mr. Pierce's report with any sort of critical eye. It simply parrots, it's 11 or 9 items that he says require further scrutiny. Let me just tell you why I know this. Because CPS, in its original affidavit, had said that the retrenchment cost was a provision that had not eventuated. SASA said, when it was asked to deal with these particular issues in the affidavit on relevance or otherwise, said it has no difficulty from its perspective, to the extent it's relevant, with those retrenchment costs being not being counted as an expense, because in the passage of time, the provision, the facts relevant to the provision didn't eventuate. There's no wrongdoing, there's no suggestion that KPG and Mazars were out of line or didn't apply correct standard in making the provision. It simply did not eventuate. So it defies logic that when submissions were made in respect of the Section 38 reference that has now been, the order that's now been withdrawn, that item still remained and still remains in the heads of argument. No one is reading what people have to say. The frames of reference in Section 38 on the part of Full, on the part of RAIN, on the part of SASA, and on the part of Treasury are all identical. It's only, when my learner says only SASA had a difficulty with the terms, well, that's yes, because SASA had difficulty with the breadth in which those terms were set out. I will, when I get to the practical considerations, address the court on if there's going to be a Section 38, what we think should be there and what its ambit should be. But what one cannot have with respect are things like this. If I can just take you to the proposed terms of reference under the former Section 38 order, which was given without oral argument on relevance or anything else. But if I could just take you to the proposal, the draft terms of reference, what pages? I don't know if I have a page for you. This is not the paginated file. Sorry, I will get it for you. But might I just say, one of the difficulties that was filed with Full submissions of 26 March 2025. It was included there and it's attached. There are, at page 4 of those, of the, and what was ordered by the court, are 9 items, which includes retrenchment costs that ought not to have been there. So the other 8 items, it's not just left on the basis that the referee should determine whether those 8 items fall to have been correctly accounted for in the KPMG and Mazars verification reports, which should have been the brief. Instead, you've got Schedule 1, where this referee who is to conduct the inquiry in an inquisitorial manner is meant to go on a general audit of whether Cashmaster incurred and paid the amounts reflected as expenses in the audited statements of KPMG and Mazars, and to the extent that it did so. Mr. Pierce had conceded in his report that he only had problems with these 7 items or 8 items. He said everything else is fine. Yet the referee was asked to do a complete re-audit of every line item in Schedule 1. With Schedule 2, whether all of the income which CPS received under the lawful contract was reflected as income in the audited statements. That's every line item. Whether the transactions between CPS and Net1 created rights and obligations that would normally be created between persons dealing at arm's length. And I can go on. But all of those are simply questions which relate to only 8 relevant items in all of this. I accept that some of them are large, that were to be referred to the referee. So that was part of our problem. Now, it is true that we took some of the other items out. We don't mind putting them back in. I'll give you an example when we get there. But the point that has to be dealt with at this stage is, from the SACA's perspective, there can be no finding by any referee that entails what Mr. Bundler and my learned friend refers to as unlawful payments. If that's what Mr. Bundler and Full thought the referee was going to decide, we cannot be party to such a reference, at least without an argument as to why we shouldn't. And the reason why we shouldn't is because we are not in the firing line under the orders to which this relates to repay anything. If we're going to be in the firing line, it will be pursuant to a separate proceeding to be instituted, where the extent of any unlawful payments will have to be referenced and proven in a lower court, not only with reference to the factor probanda, whether it's a voidable preference at the hands of the liquidator, or a setting aside of the corporate personality and a repatriation of profits, or treating the parties as one. None of that. The court can have no regard in that to what was found in this matter regarding CPS's profits, for 2 reasons. A, because it's not meant to be a proxy for that. It's meant to be an accounting. And B, as significantly, LSACA is not a party to that determination of the profits. There's no rights, and we're not entering into that fray. We're not intervening. We've made it very clear that to the extent we're analogous to a witness, we will furnish such documents to the extent that they exist and that they are relevant. I will deal directly with the question of relevance. Whatever you order, that question will have to be determined ultimately by the person dealing with, whether it's Treasury or whether it is a referee on either an extended or limited brief. We are not going to agree to an order unless we have to, under pain of an order that we have to account for all profits made by LSACA, either on its own or from this contract, whatever that may mean. No doubt, we must furnish what documents must be given that are relevant to the determination of CPS's profits. If Treasury has applied its mind and it still thinks that some of these matters are still outstanding. For example, retrenchment cost has resolved itself. It may, after it considers what is said at the inquiry, resolve itself even on such matters as the royalty payments, which are very closely scrutinized in audits in my experience, because those are related party transactions and constitute transfer pricing under Section 31 of the Income Tax Act and are scrutinized by SARS as well. I'm not saying they can't be part of the discussion, but it just seemed to me that Treasury should apply its mind a little bit better to Mr. Pierce's allegations rather than just accepting them at face value. So with that in mind, it seems to me these are the possibilities that the court has given, and LSACA makes these submissions, not with a view to avoiding or minimizing anything, because it is not being it's not being sought to be liable as a party for anything, but simply as to what would be the most expeditious and cost-effective way to resolve this. It seems to me that the process ranges from the following. The most robust approach would be to say Mr. Pierce was unable to come to a conclusion. He didn't even give a qualified opinion. Treasury has not sufficiently applied its mind to the question of what is actually needed to determine CPS's profit, and we must live with the best that we've got, which is what KPMG and Mazars did, less the retrenchment costs, and one other adjustment that has to be made. That adjustment is the following, and it's also common cause. The KPMG report brings to account as income amounts that were ordered by Judge Tsoka to be repaid. That's the 600 or 700 million rand claim that Mr. Smith talks about that SASA has. That's a claim that arises from the order of Judge Tsoka that the bulk registration amounts have to be repaid, that those were not regularly agreed. So that's a liability that exists insofar as CPS is concerned, but it's been treated as income in the KPMG and in the KPMG report. Whatever income is attributable to that, it's the 277 million rand ex VAT plus interest, will have to fall to be deducted from what income was payable. If that's right, then CPS made a loss under this contract. But of course, that doesn't mean to say the court cannot have some interest in what Mr. Pierce has to say. And the way to deal with that, it seems to me, is either to say, well, he tried twice. He never gave the court an audited verification. Treasury has not paid sufficient attention to its own obligations under this order. And therefore, there is a need to bring finality by simply accepting 3 common cause facts: the 252 million, an adjustment upwards for the retrenchment costs, which have been itemized somewhere as to a number, and a reduction by virtue of whatever is due under the Tsoka order that was taken into account in determining those payments. Those matters are all addressed in both of our sets of heads. But if the court has misgivings about the robustness of that approach, we're then into some kind of procedural order that would most cost effectively and quickly facilitate a determination of CPS's profits. SASA would object to a determination by a referee to the extent that is what it entails, that would have anything to do with liability. We never understood the reference to a referee to be anything other than to gather information relevant to seeing whether or not the audited process attended to by Mazars in KPMG was right or wrong, and to give a recommendation to this court as to how that's to be adjusted. If my learned friend for Rain believes that the referee was to make a finding that there was an unlawful profit sharing, we don't believe that is within the realms of what this court can competently order, without SASA having been joined as a potential defendant at some point, and it isn't even a party to the CPS accounting regime at all. If, on the other hand, there's to be a more limited Section 38, which involves something like Judge Rogers indicated, or Justice Rogers, which is to get information, as unfortunate as that may be, that it might involve another step, I don't think it's avoidable. Because as Justice Rogers points out, Treasury needs to be guided at some point here by an independent accountant or someone that they employ. Whether they are going to be doing that through a referee, or whether they're going to be doing an in-house appointment to assist them to do something they haven't yet done, which is to make sense of what the liquidator has furnished and see if there's still anything remaining, and to narrow the inquiry, is of little moment. They need to do something further. So we would have no objection either to a Section 38 inquiry with which full will cooperate, with which SASA will cooperate, for obtaining documents that go to the 7 or 8 questions that would have been referred to the referee. And we would have no objection in assisting Treasury on its own devices with coercive powers, if necessary, to furnish that information directly to Treasury. The relevance issue, it seems, will have to be determined by the party dealing with it. We accept, and we did accept for purposes of the aborted Section 38 reference, that there can be accounting inquiries into, that's what we agreed to, and our formulation is in our heads, which is at L1 to our heads dated. 26 March 2025. In our submissions, we gave our formulation of our proposed terms of reference. Instead of referring generally to profit, and we took the whole of Schedule 1 out, which is these general inquiries about looking at every line item. We said the referee must assess the matter from an audit and accounting perspective. We think that's very important, because the referee should not be blindly reporting on matters that go beyond the all pay to order itself. And what we are prepared to accept is we can put the royalty payments in there. There's a big amount that changed. I don't want to make submissions now about whether the auditors did or didn't do a proper job. I think it's unlikely that they didn't, but we can put the royalty expenses in. My learned friend said we wanted to take it out, we can put it back. The BE expenses I don't understand, but we can put it back in. Because once they were incurred, if that's what the evidence was, it makes no difference for CPS's all pay to order whether they were legitimate or not. If they were paid without a contract, but were paid in order to further something to do with the contract, then CPS may or may not have a claim.
Your time is up.
It's not time up. Okay. So we have put the items in,
Yes.
and we think that if there's going to be a reference, it should be limited to those items, which we've identified in our draft section 38, with which we will cooperate, because it seems to us that what is relevant there is more focused on what all pay 2 required. Thank you. Sorry, Justice. Apologies for overreaching my time.
Thank you. Thank you, Mr. Blow. Colleagues?
DCJ? Mr. Blow, just one point of detail. You said that if we were going to go the most brutal route and just live with what KPMG and Mazars have currently certified, you said apart from reversing the retrenchment cost, which would push the profit up, you said there's also the amount of Judge Talker's judgment, but that was in fact accounted for in the final 6-month extension. And that's all, it's in the figure of 253 million over 6.5 months.
Yes, but that's accounted for, Judge Rogers, as income earned. That income was
no,
not...
it's accounted for that it's now a loss. You'll see it's actually in paragraph 33 of your initial submissions.
Sorry, let me just see if maybe we might have got those submissions wrong.
Well, if you could just check that. My understanding is that because of that judgment, and if you do the maths, you can actually see it works out. Okay. The amount of...
let me just see if I can get there. So I may have misunderstood it. Apologies, Judge Rogers. You may be right. Let me just make sure. I've been asked to mention it more than once by my clients, so let me just see that I'm not double counting here, which is effectively what the risk may be. I'm just looking at paragraph 33 of our initial submissions.
Yes, there was a loss of 556 million recorded for the final 6 months, and that is arrived at. That takes into account the Talker J judgment.
Just have a moment, please.
You can check that. I'm pretty sure that's right, but that's my understanding.
Yes, it does look like that. If there's any, I'll take another instruction, but it does seem to be. The overall position is that CPS reported audited earned profits from the invalid as 253, yes, which it does include a deduction for the 556. That is the way I'd understood it. I'll find out from our client why we're still persisting in that. I did overlook that. But I take your point. Unless there's some reason for me to come back to the court with something very material in that regard, it does seem that your observation is correct.
Thank you, DCJ.
Thank you, my brother.
DCJ, if I may, Mr. Blow, the submission you make that on a robust approach, one should then steer away from a Section 38 inquiry, because then, as my colleague has just broached with you, one comes to that figure of 252 million. But in the event of a Section 38 inquiry, the other alternative, it does seem disturbing that Treasury has not had regard. It would seem, we'll hear from Mr. Maneche later, that they've not had regard to the transcript of the evidence, nor have they sought to procure the information that's on 2 laptops sitting with the liquidator. Shouldn't that happen first before one even starts thinking of a Section 38 inquiry?
I agree. It's not for me to dictate to Treasury, but I did preface it with the following statement, Judge, and perhaps it didn't come out forcefully enough, which is this. That's quite correct. Insofar as one is going to have, I said, either a Section 38 inquiry, or Treasury is going to be empowered in its own right in some way through coercive powers or otherwise to make the determination that it says it is still able to make. It does seem to me that it should, I said, acquaint itself with what happened. It should interview whoever it needs to interview, and should update this court, not just parroting a 2022 report by Mr. Pierce, but to take account of all subsequent evidence to see whether it is still unable, and if so, in what respects. It may be a much confined position. I mean, I just want to give an example why that is prudent. and I just want to get back to the royalty payments. And I'm not saying this is an accounting expert. This appears in legislation. Royalty payments from a subsidiary to a holding company in respect of intellectual property which is used by the subsidiary for its business, but which is owned by the insolvency company, is not an uncommon matter. Management fees paid by subsidiaries to holding companies here and overseas, instead of being incurred, the expenses being incurred in the subsidiary itself, are not uncommon matters. But because those are related party transactions, they require specific consideration by the auditors concerned. And if KPMG and Mazars and Deloitte all missed it, then there's something to be considered. But if they didn't, then the fact that Mr. Pierce has concerns is not enough reason to come to this court and have a Section 38 referee appointed. And that's why we took it out of our list. So that just is an example. It further requires a full ventilation in front of SARS, because to comply with Section 31 of the SARS Act, you can easily see how the tax base of a income-earning company can be eroded by overstating expenses insofar as those expenses are invoiced by a related party. So it increases the taxable deduction, the cost in the hands of the subsidiary, the profit, as it were, so-called shifting of profit. The income goes as a management fee to the holding company, who may be in a different tax position, and that's why there's a special section dealing with it. I'd be very surprised if this escaped the attention of 3 auditors and the Revenue Service. But I can't stop Treasury investigating what it wants. It just seems to me there's been, with respect to Treasury, an inadequate application of its mind to these issues and to the evidence that has been produced by CPS at its inquiry, both with respect to whether it's sufficient evidence and with respect to whether there's a prospect of getting anything more, which are 2 questions which were raised by us and by Mr. Smith in his heads previously. So I don't disagree with that observation, and we have said this for some time. Thank you.
Thank you, ADCJ.
Thank you, my brother.
Mr. Blow, just one question from me. Thank you.
Sorry, it's not coming up on my screen. Judge Collipin, thank you. Justice Collipin, yes, thank you.
Yes, thank you. Mr. Blow, mindful of the distinction you sought to draw between the obligation to account and the obligation to pay, and accepting that, and even if we proceed on the basis that what the earlier orders of this court contemplated was certainly an obligation to account.
Yes.
That could have been followed in due course by an obligation to pay, following an accounting and a full accounting to this court. And so, leaving aside that distinction, and given the concerns that have been raised during the course of this hearing, as well as in the submissions of the parties, as well as on the part of the liquidator, would the robust approach not leave, as it were, largely unfulfilled, a proper obligation to account? And the fact that we're here today must be evidence that the obligation to account hasn't been discharged. And that's an important shortcoming, just not in this process, but in terms of the whole scheme of the litigation thus far, and really the aftermath of the court finding that this contract was an illegal contract. Leaving aside whether it was corruption or not doesn't really change matters. And so that's almost an unpalatable conclusion. And in part, it shouldn't be made any better because of the issues that you raised, for example, that the audit becomes difficult because CPS and other businesses in the period of the contract does not coincide with the financial year. I'm not an expert in those matters, but I don't think those matters are fatal to a proper determination.
No, and I wasn't suggesting that, Judge Collipin.
Okay.
I was just saying that's given rise to the complexities. I wasn't saying they were indeterminable.
Okay. And would you accept that on the question of royalties, and even though you speak of, in a sense, what happens in practice and related party transactions, etc., may provide some explanation. Currently, on the papers before us, we don't have an explanation for that other than allegations that trigger valid and credible concerns.
I'm prepared to say the following, Judge, Justice. Whether they're valid and credible or not, it's not clear to me, but I will concede the following. and I said it, if there is going to be, if Treasury is going to consider the question, it should be considering the evidence that was given to 3 sets of auditors in connection with, on any version, a material related party transaction. I was saying no more than that. All I was saying is it may resolve that inquiry. I am not propounding either the robust or any other interpretation, particularly given the, a remedy, particularly given the subsidiary role that LASACA plays in these proceedings. I mean, I have knowledge about certain things, about how Section 417 is worth, about how accounts work. But at the end of the day, the court has to decide, you're quite correct, with the, let's call it the public accountability aspect of the order, quite apart from payment, best be given effect to through one or more of these approaches. I'm not prepared to say that the overly robust approach is the necessarily correct one, but I do think that the scattergun approach with heavily laden suggestions that a referee would be determining matters of liability should not be acceded to either. One way or another, LASACA's position must be respected in the sense that it is not party to any order that might oblige it to repay, and nothing this court or the referee says should have any influence on whether those proceedings could or shouldn't be brought. It is not being asked to chip in on that.
I accept that. Let's leave aside the liability to pay, but given the interconnection between CPS and LASACA, and given that the duty to account, if properly discharged, will, and as we've indicated, have the result of probing both the affairs of CPS as well as the limited affairs of LASACA, to the extent that there's those, and invariably what happens in a probe with regard to the profits of CPS will brush up against LASACA.
Yes, and in that respect, LASACA has said, it's on oath as saying it, it's been a long time ago, it doesn't have, but we are not suggesting that LASACA would in any way seek to obfuscate or obstruct those proceedings. If documents have to be looked for again, they'll be looked for again, etc. We're not suggesting that we won't fulfill whatever role we are required to fulfill by this court if it orders, for example, that after Treasury has considered everything and has a more focused attention on such matters, we will comply with whatever request is within LASACA's remit to do so. And hopefully we'll avoid disputes about relevance if it's tailored properly.
How will disputes of relevancy impact on LASACA if ultimately you may be right that it won't result in an order to pay?
No. If it's relevant to a determination of CPS's profit, even from an accountability perspective, we'll have to comply. There's no question about that.
Okay, good. Thank you, Mr. Blue.
Thank you, my brother. Any other questions, colleagues? Thank you, Mr. Blue.
Thank you.
Reply, please, Mr. Koutsouris.
Thank you, Acting Deputy Chief Justice. Can I just check, Acting Deputy Chief Justice, would it be appropriate for me to wait to hear what Mr. Manechi for the Treasury has to say to us? He said he would respond before I reply, but I'm in your hands as to the order.
Mr. Manechi?
Thank you, Acting Deputy Chief Justice. There were 2 questions which I needed to obtain instructions on and to respond. The first one related to the Section 417 documents that were provided by the liquidator. And the question was whether Treasury considered those documents before making the conclusion in paragraph 13 of its August affidavit, which is at page 599, where it says, while some information has been provided by CPS liquidators, the vast majority of the other information requested by the National Treasury has not been provided. Consequently, the National Treasury is in the same position and cannot proceed to make any determination. The absence of this information renders the determination of the profit and a futile exercise. I obtained instructions and the officials of Treasury that gave me instructions contacted the acting Accountant General, who Ms. Karen Marie, who deposed to the first affidavit and I think supported Treasury's second affidavit. And the instructions I obtained is that all the documents that were provided by the liquidator, firstly, they were indeed provided by the liquidator in 2023. Those documents were considered by Treasury before reaching this conclusion that it's still not sufficient information that enabled it to determine the profits. Except that it did not go back to ask for the laptops, so that item of source of information wasn't considered. And in addition to that, that after the information from the liquidator was provided, the acting accountant general met with the liquidator to deal with any outstanding information, and the liquidator confirmed that the information which National Treasury required was not available. So that's the instruction I received. So of the information that Mr. Smith mentioned was provided to National Treasury, the only item where Treasury was invited if it needed to access the documents but didn't obtain access was in relation to the 2 laptops. But otherwise, the other information was considered. The second question related to the coercive powers that potentially could be given to National Treasury to subpoena documents, subpoena witnesses, and determine questions of relevance. The Treasury's response on that is, firstly, it's not a function that falls within the mandate of Treasury. But in addition to that, there is a capacity problem in that Treasury would require to procure resources outside of National Treasury to perform that function, which involves discharging investigative functions with coercive powers. And so the submission of Treasury is it would not be an appropriate way to resolve the problem of provision of information to Treasury to resolve the determination of profits, but that perhaps a tailored Section 38 process might be the more appropriate route, which involves the gathering of outstanding information, producing a report which goes to a court and then ultimately goes to Treasury to determine profits. That might be the more appropriate route. That's the response, Acting Deputy Chief Justice. Thank you.
Thank you, Mr. Manage. Questions, colleagues? Thank you. Mr. Koutsoudis?
Sorry, before Mr. Koutsoudis replies, might I just formally make the correction that Judge Rogers queried? What is set out at paragraph 33 of our heads regarding the reduction already being taken, of the Tsoka order being taken into account in the net profit calculation of Mazars is correct.
Thank you. Mr. Koutsoudis?
Thank you, Acting Deputy Chief Justice. Thank you, Justices. I'm going to try and, I only have 10 minutes of protected time, and I will try to be very brief on one or two replies. As I understand it, where the large debate now seems to be between the court and the parties is either one of 3 types of options. A Section 38 inquiry, which is more fulsome and will determine the profit of CPS largely in line with what was ordered in December 2024. A more humble Section 38, which simply tries to investigate the outstanding information and then reports back to the court for Treasury then to make the determination of profits. And perhaps the third option is no Section 38 at all, and Treasury is asked to make a determination. There is some debate about whether that would be with subpoena powers or without them. as I understand the latest submissions from Treasury, they are most interested in the middle option, which is a limited Section 38. And in that regard, I want to just begin by making this submission, and it's to engage this debate that's happened that Mr. Justice Rogers has had about looking forward, because I think one of the issues the court needs to weigh. So one of the major issues to weigh is the costs and benefits, and another issue to weigh is finality. And obviously, one we've said in our heads, and this court is well alive to, we should try to avoid an iterative process with continual returns to this court if at all possible. And Mr. Justice Rogers has raised the query with I think my learned friend for Lusaka, and I think possibly with also my learned friend for CPS, whether if there was a Section 38 where the 38 determined the profit, that would mean that there would be further disputes of facts in front of this court, versus whether if Treasury does the report, that would then allow for review in the High Court. And from Freedom Under Law's perspective, we're not so sure that it's as simple as that one would lead to debate in front of this court and one wouldn't. Mr. Justice Rogers, Justice Rogers, my apologies. My understanding of the way that Section 38 works is that one of the things that a Section 38 can be done, and in fact, as you know, and as we know, Section 38(1) specifically envisages the Constitutional Court being one of the courts that can use a Section 38. And what that allows for is a number of different types of investigation, but one of them is for an accounts issue. And the court, and then Section 38(2) allows for the court to adopt that finding as its own finding. So I'm not, and that doesn't mean that there can't be debates about whether it should adopt or shouldn't. But the debates, to my mind, are debates around whether there's something improper or something that necessitates this court not to adopt. The purpose of the Section 38 is very much on a factual question, not a legal question, but a factual question. And my understanding is that profit made is a factual question. That finding is a finding of fact that this court can adopt. And in fact, it would be better placed to adopt that and more defensible, because Section 38(2) says it can do so, than if a Treasury report came before it. Because then in the world you're envisaging, Justice Rogers, you're envisaging a world where Treasury reports on this, but if any of the parties say, we don't like that report, then a whole new review process begins, and we don't even get to the question of asking whether that profit is repayable. And so I must say, I'm not, Freedom Under Law is not convinced that a Section 38 report to this court necessarily involves redebating those issues. And I must say, I'm given some comfort by that view, in that this court did the thought experiment with a 38 in the Black Sash matter, which I was involved in, both in arguing before this court and in the witness examination and argument in front of the referee. And my understanding is that the report then was large. I mean, my recollection of the judgment is that there weren't massive disputes about accepting it, but the court took the report and then allowed it to then make decisions about ordering costs. So it didn't actually lead to a new factual debate, in fact, foreclosed debate, which is why I'd always thought a Section 38 inquiry was an elegant solution, because it allowed this court to use the Section 38 to get to a factual determination. So that would be my submission. And I know it's protected time, so there may be questions against this, but let me go quickly through my other answers, if I can, unless you want me to waive protected time and debate immediately, which I'm more than happy to do. Okay. Then can I just say, so that's on the 38. I am the other point I want to make, because there's a lot of back and forth about the fact that there has been this report. Of course, Freedom Under Law has never been provided to this report because we weren't a witness, but a record that exists from the Section 417 inquiry. The mere fact that exists and that Treasury could look at it, and there's some debate about has it fully looked at it, and it says it now that it has, but there's no reason why the Section 38, with the same terms of reference that this court had previously ordered, couldn't, as a starting point, be directed to consider, of course, that evidence, that Treasury report, and couldn't be directed to take up the offers that my learned friend for CPS makes on behalf of the liquidators, to help someone to consider what's in that transcript and to make available the laptop. So I'm not sure that the fact that that hasn't happened, that couldn't be given to the Section 38. And indeed, our submission would be that it should be given to the 38, of course. We're not interested in reinventing the wheel. In the same way as the RAIN reports will become before that, obviously those facts will. But on the question, my learned friend for CPS quite fairly concedes or accepts that the Section 38, the inquiry that has happened in front of Justice Joffe doesn't finally determine the profit, nor was that its purpose. So that it doesn't coextensively answer all the questions, which means that even when Treasury looks at it, it is not going to coextensively answer it. And he fairly conceded that there wasn't a magnifying glass placed. And there may be some debates about how much of a magnifying glass, but it does concern me, having never been part of this or seeing the transcripts, that if someone is looking at this, if the question wasn't raised, not whether royalties are something that exist, but if the question wasn't put, and if Mr. Pierce's lawyers weren't allowed to cross-examine on this, two questions which would seem to be highly relevant, which obviously weren't put. Question A, it's one thing if royalties have always been one way, but how come for 2 years the royalties were X, and how come thereafter they suddenly became 400% greater, and then 500% greater? Leaving aside the huge once-off payments in May 2014 and September 2017, leaving those aside, what is the explanation for that? Because that would seem to be highly relevant, whether there's been an attempt to reinterpret or do something new. And secondly, where the party in question has reported to the people it's tendering to that the royalties will be X when it's explaining its cost structure, how that cannot be what actually happens, because those questions must be highly relevant to whether something has happened that should not have happened. That's my submission on that. Then I want to make this point, because my learned friend for Lusaka made quite a lot of the question of his client's liability. Freedom under law is quite clear. We accept that the purpose of this court's inquiry is to determine, either before Treasury or the Section 8, to determine what the true profits of CPS were, what the profits were. And indeed, this court has said so as much from All Pay 2, said in paragraph 70, the public is entitled to know the extent of the benefit. So the public is entitled to know that. Thereafter, the question will become, is CPS liable for that amount? And my submission only goes to dealing with the question of practicality. My submission is that if this court were to find that CPS is liable for X amount, it certainly would mean that the liquidator and its creditors might consider other options to obtain that money from Lusaka. But I'm not suggesting for a moment that that would be before this court. That would be in further proceedings. I would just like on that point to make a minor correction. My learned friend for Lusaka suggests that setting aside certain kinds of dispositions, in particular collusive dealings, is only the duty of the liquidator. As I understand it, Section 32(2) allows a creditor to do so where the liquidator has not, if they indemnify it for costs. So it's just a minor issue. And then on this question about what, and I did allude to this, but I think it might be relevant because this court may have to at least apply its mind to this, but I've already submitted it's for the next round.
Your time is up, Mr.
Can I make one last submission, and then is that possible?
How long is that? I'm prepared to give you only 1 minute.
1 minute, okay. The 1 minute submission is this. My learned friend for Lusaka said that the SCA has interpreted All Pay 2 not to mean that repayment is required. That's referring to the Phumelela judgment of Justice Gorvin. As you will know, that there are two competing views of All Pay 2 in the SCA. Central Energy Fund took a different view. But most interestingly, the special tribunal in a recent case of SIU versus LNG 2024 ZAST 1 considered that and said that it was not bound by Phumelela because they said that Justice Gorvin had not properly applied its mind to all of this court's jurisprudence and had failed to consider All Pay 3 and had failed to consider the later judgment in Shabangu, where Justice Farnham himself interprets his own order and his own judgment in All Pay 2 in a unanimous judgment, and found that the profits must be repaid. If you read section 27 and 28 of Shabangu, it's quite clear that the no profit means that the profits will be repaid under the no profit principle, and he specifically refers to All Pay 2. So under that authority, the Special Tribunal took the view that Justice Gorvin was wrong and that the Special Tribunal is not bound by what the SCA said, but what this court said in All Pay 3 and in Shabangu. I simply make that submission. Thank you, Deputy Chief Justice.
Thank you, Mr. Koutsoudis. Any questions, colleagues? There are none. Thank you very much. And thank you to all counsel. Judgment is reserved and the court will adjourn.
Thank you.
Thank you, Justice.
Thank you, Justice.
Thank you.